following program does not have a normal intro because I was really too busy smoothing other things over to get it done. So, Ori? Good evening, everybody. Welcome to the following program. I'm your host, Joe Neerman, a.k.a. Good Lawgic. I literally just walked in the door less than 3 minutes ago. Like the timing as far as driving back from Brooklyn, which is where tonight's party was spot on for coming in and doing a show. If there's anything that's happened in the news in the last 4 hours, I have no idea what that was. So if any of you want to call something to my attention, I would be most appreciative of that. But before any of you do that, I want to call attention to Bella Stella. Bella Stella, you my superstar, Bella Stella. You are amazing. I saw here that Bella Stella, in case any of you missed it, dropped 10. Count them. 10 more. Good Lawgic memberships. You are awesome for that. I'm gonna hit you up with one of these. You deserve that. You earned that. And I'm gonna just point this out. Following people who were gifted really should offer a thank you to Bella Stella. Those people are Richie Rides, gifted a membership by Bella Stella, Darren M. Stutz, Zena B, The Unexpected, Joni Miller, Ms. Mo, Hallie P, Draron Fury, MDW, Nunya, all of you gifted members of the following. The following is not at all a cult type of cult. Everyone knows that. It's like the talk of the town. Did you hear about that group that is like not at all a cult type of cult? Not at all. That there's no leader. It's called the following. There's no leader of the following. That's right. There's no leader. It's just purely just the following. That's all it is. There's no Kool-Aid, no spaceships, no self-harm, no harming others, no tracksuits that are mandatory. There's mild farm work, very mild, light tractor work, no squirrel mutilations, no goat sacrifices, no throwing blood on the walls, no chucking virgins in the volcanoes. Very strict no on the chucking of the virgins in the volcanoes. It's all about really just community unity and greater personal growth, which who doesn't need that? Everyone needs that. Anyway, so welcome to Following, all of you. And again, I'm not the leader of the Following. I am not the leader of the Following. I'm a member just like you. Anyhow, with that being said, so thank you, Bella Stella, for that. You're awesome. We should probably get in on this whole First Amendment, issue that's, well, they call it a First Amendment issue, and it's a really, really interesting thing because obviously, we're all big fans of the Constitution and First Amendment, and here we have these social media platforms which are saying we have a First Amendment right to decide who the heck we're going to throw out of our platform, and that is what the Supreme Court has been dallying with this week. So we're going to hear oral argument on it. Now, there were two oral arguments. One of them was a case of NetChoice versus Paxton. That was Texas case. There was another one, something with an M. I'm drawing a blank on it right now. Which that was Florida bill. The Florida bill, they argued for 2.5 hours, followed up by 1 hour and 20 minutes of oral argument on the Texan bill. I don't have 3.5 hours to do this. I don't. I wish I did. Because really, let's face it, when I cover these things, whatever amount of time we're listening to them, I'm also giving my thoughts, so it ends up taking a lot longer than 3.5 hours when you go through it. I'm probably going to go through some of that. It's the other case, which actually they argued first. So arguing on behalf of the state is Paul Clement, who basically every time we have an argument that comes before the Supreme Court and there's someone there who's arguing for the angels versus arguing for Satan, the one arguing for angels, I'm convinced that 100 years from now, when you go up to them pearly gates, and there's going to be all these arguments there. Some of you might be saying, like, you might say St. Peter, whatever you want to say, whatever your religious denominations say. We're not big on the whole St. Peter thing, but you might. The person arguing there on the side of the angels is going to be Paul Clement. That's what it's got to be Paul Clement. Every single time. This guy is like sitting there and he argues very effectively, very, very powerfully. He's a really, really good lawyer. He's a really good lawyer for the good guys. So I don't think he gets enough recognition. I don't think he gets enough acclaim for what he deserves. This is a guy who's fighting in the trenches, fighting effectively in the trenches on issue after issue after issue after issue, always on the right side. So today and it's actually yesterday's when these oral arguments were held. Paul Clement back at it again. Let's get into on these oral arguments right now. Let's do it because I want to hear it from Paul Clement. Paulie. That's what it was. Moody versus NetChoice. That was the other one. Moody versus NetChoice. I knew it was something in them. All right, let's check it out. Let's check it out. Oh yes. I can really make this a little smaller even. It's not smaller. There you go. You're not going to see anything anyway. It's no video. It's just audio.
Excludes websites.
Whoa.
We will hear argument next in case 22555, NetChoice versus Paxton. Mr. Clement.
Mr. Chief Justice, and may it please the court. I don't want to proceed as if I wasn't here for the first argument, so let me focus on what's different about Texas. One thing, fortunately, that's different about Texas is its definition of social media platforms excludes websites. So we can just put that Gmail issue to one side for when we're talking about Texas. The other thing it excludes, of course, is websites that are primarily focused on news.
I'm thinking for a moment here. It probably would be best if I would actually pull up a brief. I'm going to pause here. I want to give you a little more background here so you can appreciate what it is that we're talking about. So I don't like walking in quite this fresh. We need to understand a little bit more about what this case is about, so you have a little bit fresh. You have a better grip when we're listening to these oral arguments as to precisely what the nature of this oral argument is about. So let me pull up a brief synopsis here of what it was. I had it here earlier, but I'm just I can find it pretty quick. Let's do a quick review of the facts of this case, just so we're on the same page, okay? So do it this way. State of Texas enacted HB 20 to regulate large social media platforms, such as Facebook, X, formerly known as Twitter, YouTube. The law purports to prohibit large social media platforms from censoring speech based on the viewpoint of the speaker. Because let's face it, when they're censoring the viewpoint of the speaker, they mean me, okay? That's who they're really, that's what this is about. Texas is trying to protect me from big tech. That's essentially what this is. Me and my ilk. It's really not me. They weren't thinking of me. To be fair, they're really talking about Alex Jones. That's what they're really talking about. But that's essentially what the objective of the law was. NetChoice and the computer and communication industry filed a lawsuit against the Attorney General of Texas challenging two provisions of law as unconstitutional. Section 7, which prohibits viewpoint-based censorship of users' posts except for content that excites criminal activity or is unlawful. So let's pull up here. I'm going to pull up HB 20. HB 20, Texas. Text. Because we'll see exactly what it is that they are looking at. Section 7 that they're objecting to. Section 3, it was Section 7. Section 7, Section 143. Did I miss it? It's possible I missed it. These things run together. Where are you? Section 7, Section 7. Section 3. Let's see if we can find 7 here. Control F. Section. Section 4. Oh no. What? What? Oh no. What did you do? Prohibits viewpoint-based censorship of users' posts except for content that incites criminal activity. Let's look for viewpoint. So we find that. Viewpoint. So I guess this is it here. The social media platform or interactive computer service may not censor user or user's expression or user's ability to receive the expression of another person based on the viewpoint of the user or another person, the viewpoint representing the user's expression or another person's expression, regardless of whether the viewpoint is expressed on a social media platform or interactive computer system or through any medium. So if someone expresses a viewpoint, let's say about Biden or Trump, that they could not say, well, since you wrote that, we're now going to deplatform you. That's one element to this. The other is Section 2, which requires platforms to disclose how they moderate and promote content, publish an acceptable use policy, and maintain a complaint and appeal system for the users. So this is requiring this transparency from these different social media platforms, saying that you are hereby obligated to disclose what moderation and promote, not just moderation, but let's face it, we all know that this is all about the algorithms, right? It's all about the algorithms, and that we've seen how X, formerly known as Twitter, we've seen YouTube, we've seen Facebook, all of these super big tech giants will create algorithms that are designed to promote one type of message and make it almost impossible, obscure messaging that goes against the narratives that they favor. So that's why they need to have transparency in Section 2, which requires platforms to disclose how they moderate and promote content, publish an acceptable use policy, and maintain a complaint and appeal system for their users. So this way we can actually see. Texas is demanding, we want people to be able to see how the sausage is being made in your grotesque propagation factories that you're creating here from big tech. And this is something that obviously big tech doesn't really like. With that in mind, the district court issued a preliminary injunction holding that Section 7 and Section 2 are facially unconstitutional. So at the first stage, district court said, yeah, that law doesn't pass muster. That's unconstitutional. The court argued that social media platforms have some level of editorial discretion protected by the First Amendment, and HB 20 interferes with that discretion. Says, hey, they have a First Amendment right? YouTube has a First Amendment right. They can decide what messaging they want to promote, what messaging they don't want to promote. On appeal, the U.S. Court of Appeals for Fifth Circuit reversed, rejecting the idea that large corporations have a freewheeling First Amendment right to censor what people say. It reasoned that HB 20 does not regulate the platform's speech, but protects other people's speech and regulates the platform's conduct with what they do with that speech. So that's not their First Amendment. There's really no First Amendment. If anything, they're just helping enable more speech. That's the root of this issue. You can see why this is a topic which is near and dear to my heart, because this literally is the sort of thing that I've been fighting with in my own livelihood for the last 2.5 years. So yeah, go get them. Go get them. The question is, does the Texas HB 20 provisions prohibiting social media platforms from censoring users' content and imposing stringent disclosure requirements violate the First Amendment, meaning violate big tech's First Amendment rights by forcing them to tolerate messaging that they don't really want to promote? There you go. That's the issue that the court here is fixating on in this NetChoice versus NetChoice LLC v. Paxton. NetChoice in this context is basically a conglomeration of those three entities. Really, it's YouTube, Facebook, and X. So with that, at this stage, the appeal is being made by NetChoice because Paxton has won. And at the circuit court level, the Fifth Circuit said, yeah, the Texas has a right to do that. And they have a right to basically dictate to big tech, and prohibit them from punishing people from expressing opinions that they don't like. So here we go.
Sports and entertainment. In the First Amendment business, we call that content-based discrimination. And that's just one of the many reasons that this statute is, dare I say it, facially unconstitutional. The other thing that's different is in some respects, this statute operates more simply because it forbids my clients from engaging in viewpoint discrimination.
Interesting. So he's on the bad side today. He's on the bad side. He's basically arguing on behalf of NetChoice that, hey, we have a right to basically engage in free speech as we want.
Now, we're used to thinking that viewpoint discrimination is a bad thing and that governments shouldn't do it. And of course, when governments do it, it is a bad thing. But when editors or speakers engage in viewpoint discrimination, that is their First Amendment right. It is also absolutely vital to the operation of these websites, because if you have to be viewpoint neutral, that means that if you have materials that are involved in suicide prevention, you also have to have materials that advocate suicide promotion.
That's not actually true. No, I'll tell you why. One of the things that they make an exception for is criminal activity and self-deletion. You see, this, Paul, you're making my point. I can't even use that stupid word because of your clients. I can't even use that because they'll basically say, oh my gosh. So by you using that word, you're showing for the world the problems that we have with big tech, Paul. You are.
Or if you have materials on your site that are pro-Semitic, then you have to let on materials onto your site that are anti-Semitic. And that is a formula for making these websites very unpopular to both users and advertisers. So
it's not a matter of. I think they should be forced to allow that. I think they should be forced to. Let people expose themselves. It's okay.
It is absolutely vital. The other thing that makes Texas a little different is, at least in passing the law, Texas was even more explicit in relying on the common carrier analogy. As if simply labeling websites common carriers makes the First Amendment problems go away. And that is fundamentally wrong for two basic reasons. One, these companies don't operate actually as common carriers. They all have terms of use that exclude varying degrees of content. And second, Texas can't simply convert them into public common carriers by its say-so. I welcome the court's questions.
Mr. Clement, if these laws go into effect, how would your clients, what steps would they take to comply?
So, I mean, one thing that they would...
Including, I'm sorry, just in particular, addressing the situation of compliance in Texas.
Let's see if I can get a transcript up here that we can look at. That'd be even better. Oh, we can. That's even better. I gotta make it a little bigger for y'all. This is something worth seeing. Can I download this and highlight? Make it a little bigger. Okay, that's worth seeing. That's worth seeing. Now you guys can read along with them. We can all read along. All right, let's go back. There we go.
And Florida as opposed to nationwide.
Sure. So, I mean, one of the things that they would contemplate, at least, with respect to Texas in the first instance, is there some way to just withdraw from the market in Texas and Florida? And of course, Texas had that in mind in the statute and specifically said by we essentially have to do business in Texas, and we can't discriminate against users based on their geographic location in Texas. So if we lose this, including the idea that we can be forced to engage in expressive activity in Texas, then I think we would fundamentally have to change the way that we provide our service in order to engage in order to provide anything like the service that we want to, while not engaging in viewpoint discrimination. We'd basically have to eliminate certain areas of speech entirely. So
So understand what he's essentially saying, that viewpoint discrimination is baked into the cake. We have viewpoint discrimination baked in there. That's what he's saying. That's what he's saying. That's not an advocacy for oh, well, since it's baked in there, I guess let's keep it that way forever. What? No, that means your whole cake basically, instead of using sugar, you use salt. And that's not good. That's not good. Sorry, that was my Jordan Peterson. And that's not good. That means, come on. Sorry. I'm in a Jordan Peterson phase. Sorry about that. I'm in a Jordan Peterson phase. Okay, and that's not good. I won't. All right, we'll get back in.
Just couldn't talk about suicide prevention anymore because we're not going to talk about suicide promotion. I guess we couldn't have pro-Semitic speech because we're not going to have anti-Semitic speech. So we'd have to figure out.
No, first of all, you're talking about two different things here. That's not what the law says. I mean, when you talk about viewpoint discrimination, it means if you want to engage in First Amendment speech, you can engage in it. If you want to have a breast cancer awareness day, that doesn't mean you have to have a breast cancer confusion day also. That's not what that... you can express yourself however you want. The point is your moderation of other people. That's the issue. No one's saying what Facebook can post on their own Facebook's Facebook page. Right? No one's stopping Elon Musk from tweeting out whatever the heck he wants and saying, well, since you're the owner here, if you talk about self-deletion prevention, then you have to also start talking about the benefits of it. No, the point is just let people talk. Make people free to talk and stop trying to punish them for the opinions that they express. That was not Indian. If anything, that was Chinese what I was doing. That was Asian.
Some way to try to engage in even more content moderation or editorial discretion to try to get us to a level where we're more benign and somehow we don't run afoul of Texas law. That's not true. And then on the disclosure provisions, the record here reflects that YouTube would have to basically increase its disclosure and appeal process basically 100-fold in order to comply with Texas law.
Well, the way you have your system set up with YouTube is garbage. It's hot garbage. I know because I've tried actually using it. The way they have their system set up right now, okay? If I was to play a video, first of all, when it comes to their copyright, if I was to play a video, depending on who owns that video, and it really depends significantly on who owns it. Sometimes nothing will happen. Nothing at all will happen. Frequently, nothing at all will happen. Other times, I'll be told that because I shared during my 2-hour stream, I shared 3 minutes of a video, that the entire revenue for that stream is going to someone else. Other times, they will block it so that nobody can see that video, which benefits nobody. Literally benefits no, it just harms everybody. Just harms everybody. At the very least, that bothers me more than anything because people wonder, did he stream last night? What happened? And I don't even realize it happened until the next afternoon normally. And I'm like, oh man, That's the sort of thing that happens with Jon Stewart. That reminds me, I should check the last time I critiqued Jon Stewart. That's what happened. Everything just like, they just clamp everything down. Who do they do that for? The superpowers that they love. The superpowers that they love. They'll just like completely block everything. So if I run afoul of the big companies, I run afoul of NBC, I run afoul of Vox. I don't know Vox anymore. You run afoul of those large corporations. If I played an SNL skit here that's 90 seconds long, I will be fighting about that for the next, and even if I stop it every 20 seconds, I'll be fighting about it for the next month. Yes, please. There's lots of dirt to be slung here. Lots of dirt. Yeah, and then there's the algorithm hierarchy is gross. So yeah, he's basically saying we have a system that's completely rigged, and we need to keep it that way, because otherwise, someone has to. We have to basically start talking about it. Start spreading anti-Semitism. It's like, no, that's not how any of this works. Just, you know what? If someone is stupid enough that they want to basically promote anti-Semitism, let them embarrass themselves. Somebody's stupid enough to start screaming out the N-word and displaying his racist colors. Do it. Stop being so afraid. Sorry, Paul, you're on the wrong side on this one.
I'm happy to talk more about the common carrier issue because I do think it's a central part of their defense. There was an allusion earlier about somehow Section 230 treats my clients, the websites, as common carriers. To the contrary, Congress specifically, and this is 47 U.S.C. 223 subsection 6, which we cite in our briefs, it specifically is a congressional provision in the same act of Congress that says that interactive computer services should not be treated as common carriers. And I think more broadly, the whole thrust of 230 is don't just be a common carrier. Don't just put through all of this material. We don't want that. We want you to exercise editorial discretion in order to keep some of the worst off the site.
It does that, though, only with all that's true, and I acknowledge all that. But it also says that's true only if it's not your speech. And that seems to be in tension a bit with your suggestion that everything is your speech.
Justice Gorsuch is now hitting on exactly what I just hit on. Which is he's making it as if like, well, if someone says something that is pro-Semitic, now I have to go out there, YouTube have to go out there and write something that's anti-Semitic. No, it's not. No. You're just not allowed to rig the algorithms. That's all. Just stop rigging the algorithms. It's really very simple. You don't have to do anything. You don't have to ever say anything. And even if you did say something, you wouldn't have to say the opposite 10 minutes later also. And that's what's the key thing there is it's not like everyone's speech there is your speech. Great question. Great point here by Gorsuch. Great point indeed. Let me see if you guys, if I push this over, I want to see how I can do this without jumping back and forth. I really don't want to jump back and forth. You guys can still hear it if I play it from this screen, I believe. You hear this, right?
I think Justice Barrett pointed out an interesting feature of that, which is
when he just mentioned Justice Barrett, you heard that, right? I assume you all heard that, even though it's not on this screen that I'm sharing. Is that correct? If you guys can confirm that. All right, thank you, John. Thank you, Ryan. Less algo censorship equals exposed Hamas supporters. Yep. That's much. It's so much better. So much better.
Is these algorithms arrange, sort, promote certain posts by users and not others? And is that not not yours, but your client's speech?
So I don't think it's our speech in the way that Section 230 talks about the speech. And I think for these purposes, you have to distinguish between the speech that is the editorial function and the underlying user speech.
I understand that. And I didn't mean to suggest otherwise, but there is some editorial speech, your term, going on, right?
I think that's right.
And so the carrier would be liable for its editorial speech.
I don't think so. I mean, I did actually reread the brief that I filed, at least in the Gonzalez case, and I think that you could make a strong argument based on the text of that statute that that kind of editorial sort of functioning is not something that causes you to lose your 230 protection.
So it's speech for purposes of the First Amendment, your speech, your editorial control. But when we get to Section 230, your submission is that that isn't your speech.
Yes, as a matter of statutory construction, because otherwise Section 230 ends up being self-defeating. Because again, the whole point of Section 230 was to promote that editorial discretion. And
yeah, but here's the thing. It is supposed to promote editorial discretion, but the editorial discretion is supposed to be governed by something. That's why it says for harassment, violence, pornography, it says, or otherwise objectionable material. I should really pull up Section 230 here for you to take a look at, because this is really, we'll see how much longer they go on talking about it. When they talk about, there's two different forms of speech that they're talking about. There's speech by these big tech platforms. There's speech that they make a statement publicly, which is a speech like I'm doing right now. I'm making a statement publicly. And then there's another form of inherent speech, and that form of inherent speech is when they editorialize, which is when they basically plug in an algorithm, which will make it almost impossible for you to find me, or make it impossible for you to find someone else. So, or make it very easy, throw in everyone's face that they're able to easily find whomever, whichever content creator, name Mr. Beast. Okay, and I'm not trying to be confrontational. Okay, my point is that person they're throwing in there, they're choosing to throw that in front of you specifically and making it almost impossible to find other people. So that too is a form of speech by YouTube, where they are via their promotion, they're editorializing, or even clamping down that it's impossible to find, that they're basically erasing people. And that erasure is an editorializing, which is them engaging in a type of speech. They're basically saying, we don't like what this person is saying. We really do like what this other person is saying. So that's a form of speech that they're engaging in, and that's which is what they're talking about. Now, Section 230 was designed to enable big tech to engage in editorializing without becoming a distributor. I do want to pull up Section 230. I think it's important for us to just sort of look at it really, really quickly. 230. Okay, this is the key. This is the key language there. So I want you all to understand exactly what's happening here and how this thing came about. In the 1990s, when the internet started exploding, and the government wanted to enable it to explode while still making sure that it wasn't the Wild West. Now you have to understand that this was a different time. This was a completely different time, and there was a whole question which was focusing on liability of these these social media platforms. This is before there's a Google. This is before there's a YouTube or even a Facebook. Okay, so now in this era where there's much less ability to control speech, there was a concern that all of these platforms had, and the concern basically came out in a case which was I think it was the Stratton case, which was basically it all flowed from the concerns about defamation. And you might say, what the heck does defamation have to do with editorializing what's happening and that whole thing? Well, there are concepts in defamation that you need to sort of understand so that you can better understand this section. Not this. That's not this platform. That's not the screen I want to give you. this section of civil liability. Now, you need to understand first and foremost this. What this says is no provider or user of an interactive computer service shall be held liable on account of any action voluntarily taken in good faith to restrict access to or availability of material that the provider or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected. This is the key element. When they argue about Section 230, this is the key paragraph that everyone is talking about. Why? What happened? Well, in the 1990s, people were trying to figure out, the government was trying to figure out, what do we do in order to enable people to host internet platforms, because we have a problem of defamation. Because it's long entrenched in American law that if I were to defame someone else, the person I defame can sue me. But they don't just have the ability to sue me. They have the ability to sue anyone else who has editorial control over my message. So, if I were to write a book, and in that book, I were to tell lies about John Smith, I were to tell lies about Nancy Pelosi, and flat out lies that were derogatory and terrible, flat out lies that I assert as statements of fact, not as opinion, and there's really no defense that I have for defamation. Nancy Pelosi could turn around and sue me and the publishing company. Why? Well, and forget about all the other defenses as far as she's a public figure, all that other stuff. The point, I'm just using her as an example. The point is, let's assume that I really had committed defamation. So she's able to sue me and anyone else who has editorial control. And she'd rather probably frequently sue the party which has editorial control, because they're usually a deeper pocket than me. And we say, you who are an editor, who have editorial control, you are considered a publisher of the defamatory statement. And anyone in the chain who is a publisher of the defamatory statement can be held equally liable to the original speaker. The original speaker, in legal terms, we refer to them as being the publisher. Even though I'm just talking the same language that we refer to as publisher publishing of books, we refer to as publishing defamation. So I, the original person, when I say those words or when I write them down, I am a publisher. And when it gets disseminated by someone who has editorial control, they too are called a publisher, and we would both be listed as defendants. Well, in the 1950s, the question was, well, what about a bookstore? A bookstore then will take my book and sell it. And when they sell it, they're helping to distribute these defamatory statements. So the Supreme Court made a distinction, and they said a bookstore is not exercising any editorial control over the content. They are not a publisher, they are a distributor. And we are not going to allow a plaintiff in a defamation case to sue a distributor, only a publisher. What distinguishes a publisher and all the people who are labeled publishers, me and the publishing company, what is that we have editorial control. We have control over the content that's being displayed. In contrast, a bookstore has no editorial control about what's written in an article. So we're going to look at them as just a distributor. And we're going to say, hey, victim of defamation, when you start a lawsuit, you cannot name the distributor. When we got to the 90s, then the question became, what do we do with these internet platforms? What do we do with these content providers, these people who had blogs or hosting a blog? How are we going to look at them? We're going to look at them as being an editor. We're going to look at them as being a distributor. Well, the government decided to try and protect them and insulate them because they wanted them to be able to engage in business of providing a place for people to engage in the internet without facing a lawsuit every 10 seconds because some schmuck in the Yukon ends up writing something terrible. Yukon's not America, is it? Some schmuck in BFE, Iowa, writes something defamatory about someone else in New Jersey, and who are you going to name? You're going to name AOL. You're going to name Yahoo. You're going to name ICQ. You're going to name MySpace. You're going to name all these different people, and you're going to name the internet platform, the platform. You're going to name whichever phone, whichever dial-up service people were using. So they basically said, we don't want that to happen. So no, they're a distributor. But then what if they start exercising editorial control? And people might have we want them to exercise editorial control? Why do we want them to exercise editorial control? We want these internet service providers to be able to engage in editorial control, because otherwise everything on the internet is basically going to become porn or violent or harassing. And we want these service providers to help protect the public so that kids can basically go online and we don't have to worry that they're going to see really disturbing imagery, which is going to mess up their minds. I know, it's the 90s. At that point, we were still worried about messing up with kids' minds. Today, not so much. So what Congress basically said is, even if you engage in that type of editorializing, that you're taking down the lewd and lascivious stuff, and you're taking down the violence, and you're taking down the harassment, so that Billy doesn't make Heather go want to kill herself. So in that case, we will still say that we're not going to say, because you took that down, now you're an editor, you're establishing editorial control, and you change from being a bookstore distributor by your editorialization and taking down all the pornographic stuff, because that's a form of editorializing when you take down someone's stuff. So we're not going to say that that's going to make you jump from a distributor to a publisher, because if you jump from being a distributor to a publisher by exercising that type of control, every internet service provider would be sued all the time for stuff that they're not even writing. They're just put a place for people to write stuff. And they would be facing lawsuit after lawsuit after lawsuit. So the government said, let's protect them. Let's protect them. And we'll say, look, even if you are engaging in that type of editorializing, we're going to keep you as a distributor. And you're still protected, that no one's going to be able to come after you and sue you for engaging for becoming a publisher. So now when there's a fight between two people about defamation, you're not going to be named as a defendant in that, because you're just labeled a distributor. And if the plaintiff says, well, they're not just a distributor because they're taking down this thing and that thing, and they took down this pornographic thing and that violent thing, so how are you looking at them as a distributor? No, the law now clearly establishes that they are still considered, despite that editorializing, they are still considered a mere distributor and not able to be sued in the chain of publishers for defamation, rather than becoming a publisher. And that was all done by the government to encourage these platforms to engage in that type of editorialization. And that all would have been well and good. That all would have been fine. But Congress screwed up, because they added in one more thing here. And what they basically said was, not simply can you editorialize obscene, lewd, lascivious, filthy, excessively violent, harassing content, but they put in or otherwise objectionable. This language of or otherwise objectionable means if you find it objectionable, you can take it down. Well, what's objectionable? And Congress is basically saying, well, anything you find objectionable, you can take down. And the internet companies, and we see this in the big social media platforms, we're all like, oh, we can do whatever we want. We're not considered an editor. We're still considered a distributor, and we're not crossing over into that dangerous waters of becoming from a distributor to becoming a publisher, no matter how much we editorialize. And they started really taking advantage of it. And they started saying, I think people who say bad things about Biden, I find that objectionable. I think people are saying good things about Trump. I find that pretty objectionable. And that gave them carte blanche to basically become propaganda machines for whoever's bidding they wanted to serve. And that's the issue that we have today. Because if they didn't have these stupid 3 words here of or otherwise objectionable, then YouTube, by saying, oh, I'm going to rig the algorithms against anyone who's promoting Trump and make it impossible for you to find them, that would be an editorialization of their platform, and that would open them up to thousands of defamation suits. Anytime someone would commit defamation on YouTube, not only with a speaker who spoke defamatorily, spoke libelously, slanderously, it would be libelously about someone else, be subject to it, but YouTube would be a defendant every single freaking time because they're a much deeper pocket. And plaintiffs' attorneys would all be going after the deep pocket. They wouldn't care about the schmuck who said it. They'd be like, oh man, okay, I'm gonna go after YouTube. I'm gonna go after YouTube. That company is making billions of dollars every day. I'm gonna go after YouTube. And they would be facing one lawsuit after another. So they rely on this so heavily that they now have a complete broad swath of editorializing that they're allowed to engage in without ever worrying that they're going to change from being a distribution label as a distributor into becoming a publisher, all because of these stupid 3 words that they put in here. If they took out these 3 words and they say, look, you can take down things that are obscene, that are lewd, that are lascivious, that are filthy, that's violent or harassing, and you'll still be a distributor, that would have done everything they wanted. They would have done everything they needed. But no. Congress stupidly put in or otherwise objectionable. Now, to be fair, back in the 90s, when this was happening, it was almost impossible for these internet service providers or these large platforms to actually monitor what was happening in real time. So that's why I said, to the extent you're going to engage in it, you're not going to have to worry about it. If you miss some, you're still not going to have to worry about it because we understand you're going to miss some. You're just doing your best. But now we're talking about dealing with computers that have capacity to literally sift through billions of posts in a microsecond and glean out, this is good, this is not good, this is not good, this is good, this is not good, on like so much information being processed so quickly that it was inconceivable in the 90s that they really could be held accountable for this stuff. They and arguably should, but this law, Section 230, is still on the books, and that's why a lot of people talk about Section 230 reform. And most people, when they're talking about Section 230 reform, they literally just mean take an eraser to these 3 words, or otherwise objectionable. And if you took out those 3 words, if Congress took out those 3 words, then none of these platforms would be able to. They still would be able to keep out the porn to the best of their abilities if they were so inclined. Not all of them are inclined. Keep out the violence, keep out the harassment without just taking out whatever it is that they want and wielding social media like a freaking sword to influence our culture. So that is what they are really arguing about here in this exchange. That's what we're seeing. That's what this whole argument when they're talking about Section 230 and the impact that it has on them. That's what this entire argument is about. Let me cover a couple of chats that came in here. Matt says, there's a premium feature in the app now for color themes filtered by video aesthetics. Really? Which app? I don't know what you're referring to. Is 230 severable as the court could strike or otherwise objectionable as too broad? Probably no. No, I don't see that. That would be judicial legislation. They really shouldn't do that. But what they can do is they can classify as a carrier and then change the entire thing here. But let's see what's happening here. That sounds like where a direction that the court is thinking about doing. So let's go a little further. Let's keep moving along here because I'm basically 6% of the way through and I'm 48 minutes in.
This court wrestled with these issues. They're hard issues. And I certainly applaud the instinct that you shouldn't resolve them here. But I don't think just by recognizing that my clients are engaged in editorial discretion when they make those decisions about what's going to ultimately go to the individualized screen that a user's going to see when they tap into their website or their application. I don't think that's the kind of speech that you're talking about in the 230 context. And if you did, I think you would defeat the fundamental purpose of 230 because they wanted you. They wanted my clients and others to exercise that editorial discretion to keep the bad material out.
With respect to other people's speech. So it seems like we have speech and then we have speech.
You can't, you literally, and this is, again, I'm happy to argue that case right now if we want to, but you can't have
Well, no, it's
Section
a really
230.
hard question for us, and it's perfectly relevant here and very important because, of course, 230 preempts things, and we don't know how much of this law it preempts.
Absolutely, but this law is unconstitutional in all its applications, and certainly it has no plainly legitimate sweep. So you don't have to reach the 230 question directly here. And I would simply say that when you're reading those statutory terms in 230, you wouldn't sweep in editorial discretion, because if you do, you will defeat the fundamental purpose of Section 230, which is to empower editorial discretion.
Well, I just wanted to raise with you the question I raised with the Solicitor General, who offered a thoughtful response. But many of your clients' terms of service, while reserving some editorial discretion, and I think about most of them as speaking about the things covered by 230, obscenity, et cetera, go out of their way to promise an open forum to all members of the public, and go out of their way to say we don't endorse what other people say on this site, and go out of their way to say all views shall flourish. Now, that's not true for all of your clients, but it's true for some of them and many of them. What do we do about that?
So I would say that, and it's true of some of my clients and some more than others. And I think all of those terms of service, as the
I understand, his clients are Facebook, YouTube, Twitter. So that's why he's saying it's true of some of your clients. Some of them have more of a promise of flourishing free speech than others. So to the extent that some of them are promising that, what do we do with that?
Said, go on to say, and there's certain things, though, that are out of bounds. And I do think it's just a factually true thing that my clients, in the main, as long as you kind of stay within the lines, they actually do want to promote an open dialogue and a fair dialogue.
That's not true. That's a joke. That's a freaking joke. That is so far from the truth. They definitely do not want that. It's inherently obvious they do not want that. They clearly do not.
And if you look at the Center for Growth and Opportunity brief, it shows you that actually some conservative voices have really flourished on these websites. Ben Shapiro and Daily Wire are killing it on Facebook.
Yeah, okay. That's the one they allow. That's basically like the new Fox News. That's what they allow. That's it. He's the only one. Everyone else gets deplatformed.
And that shows you that we do want a broad discussion, but there's some stuff that is just, out of the lines. And I don't think it's as simple to say, well, that's just the 230 stuff, because, again, we had a debate about what otherwise objectionable means. But I also think that my clients are getting a lot of pressure to be particularly careful about things that are damaging to youths. And I think in that...
See, this is why the reason I know he's either intentionally crazy or ignorant about this issue is because I know that I've seen firsthand how users get stripped away from me, literally pulled away. How many times a week will I get people saying, wow, I got unsubbed from you again. I got unsubbed for you again. I resubbed from you 4 times. I resubbed to you 4 times this month, and I got unsubbed from you. And I'm not espousing. I have never, in the 2 years I've been doing this, I've never once espoused harming another individual. I've never once espoused, I don't endorse or espouse anything remotely violent. I don't espouse hatred. I don't espouse anything that is actually objectionable, that people who actually listen to what I'm saying is promoting hatred, violence, or obscenity, or anything like that. I never curse. And yet I see how they purposefully literally rip people away from me. So don't give me your freaking Ben Shapiros. Okay, that's the one exception you specifically made for reasons that many of us can sit here harboring speculations as to why Ben Shapiro and Daily Wire are protected from on high. But he's the only one. You sit there, and I think purposefully he's the only one. I think they actually, part of the reason they're motivated to give him such carte blanche is so that they can keep saying, aha, you see, Ben Shapiro. So that disproves everything because we have one Ben Shapiro here. That's it. You see a Ben Shapiro. How can you complain? How are you complaining? There's Ben Shapiro. But I see it firsthand. And to have this guy come up in the Supreme Court and say, you see, no, there's no discrimination. If there's no discrimination, you don't have to worry. This is the other thing. You're sitting here saying that there's no discrimination, then why are you worried? Then don't go to court. You should just be like, okay, we can comply with this. No problem. There's no discrimination. There's no discrimination. Why are you arguing for, Paul? If that's really true, that there's no discrimination, all this thing is saying is, all this law says is don't discriminate. If you say you're not discriminating, what are you worrying about?
Context, they want to sort of err on the side of keeping some bad material off.
Well, you mentioned that a few times. Let me just press the other way, though. Doesn't it also hold that, on your view, part of the editorial discretion of a platform would be that it could use algorithms designed specifically to try to attract teens to addiction or suicide, depression, those kinds of things as well? That would be part of their editorial discretion too.
Yeah.
So
who says that your clients are angels? What if they just, according to you, they should have the right to basically promote whatever evil things they want?
I don't think my clients, because my clients
I don't mean to cast aspersions on anyone, but I think it's a natural consequence of your position, isn't it?
There would be protected First Amendment activity with that very different website with a business model that I don't think would stay in business very long. And it is possible, as the United States has pointed out in its brief, that if you have a different concern and you identify a different government interest, that maybe the government might be able to do something, particularly if it does it in a content neutral way, to address some of those concerns.
But basically, your argument is rooted in my clients are good people. Because what Paul is saying here essentially is my clients are trying to do right. They're trying to do good. They're trying. So if they weren't, in that case, your argument falls. So the laws of our country are dependent on whether or not we happen to have what you consider to be good people who are running things. That doesn't sound like a way to run to establish our jurisprudence.
But to get back to something Justice Kavanaugh pointed out before, I actually think that both Texas and Florida have been pretty aggressive about their government interest here being something that is not just not a legitimate interest in the First Amendment context, but is affirmatively prohibited, which is the idea that we're going to we're going to amplify some voices, we're going to make certain put burdens on private parties.
No, it doesn't. Nowhere does it say you have to amplify anything. He's mischaracterizing what this law says in order to make it sound like it's onerous, but it's not saying you have to amplify. Just don't de-amplify. That's it. That's it. You don't have to amplify anything. I don't want anyone to give me special treatment. Just don't give me special treatment. That's what I want. I'm not saying give me special treatment in a good way. Just don't give me special treatment in a bad way. Just give me normal treatment. Treat me like anyone else. Treat me like some stupid woodworking thing. Treat me like some sort of, I don't know, some popular mechanics thing. That's all. Just treat me like you would treat them. That's all I care about. I'm totally fine with that. I just want to work on a level playing field. It's really not that complicated. If people like my content and they want to watch it and they express that by dropping comments, which, by the way, please drop a comment down below. And it should be more than 4 words. It's got to be at least, I think, it's got to be at least, they say 8 words. I don't even know. It's definitely more than 4 in order for it to register with the algorithm. But, yeah. And then give me the thumbs up, which wherever you are on Rumble or YouTube, I would appreciate if you could give me the little thumbs up there. You can do it, I guess, on X too. So to help, and that triggers them to send me the algorithm. People feel inclined to show me that kind of love, and that triggers the algorithm. Don't depress that because you don't like what I'm saying. Just treat me the same as anyone else. Let me sink or swim on my own talent. Like a classic meritocracy. It's like so aggravating. Not knowing how this works, is there transparency on who's subscribed to you? The problem is, like the government, there is no transparency. Oh, I can see. But thank God. God bless right now. I got 93,000 subs. I can't sit there going day by day and figuring out who's been they don't tell me who's been unsubbed. They won't tell me that. They'll just I can go through a list of who my current subs are and see that, but they don't show me who's been unsubbed on a day by day basis for me to send them a notice to say, hey, you come back. Sorry, YouTube screwed with you. Yeah, so yeah, I can go through a list and basically find the names. If you tell me a name, I can basically see if you're subbed up to me. It's so sad. It's so pathetic and it's so transparent. Even some people who join as members get unsubbed. So don't tell me. And it's not like I say anything. I've never had a single thing. I've never expressed anything which was so objectionable that my content came down because of the thing that I expressed. With one exception, the only time I've ever been punished is when I said there should not be laws that relate to certain medicinal practices, which I don't give any medical advice. And I wasn't giving medical advice on that occasion. I was simply saying, whatever it is people want to do with their medicine, I don't like there being laws that require medicine. Now, I'm not giving medical advice. I wasn't giving medical advice then, and I'm not giving you medical advice now because I don't give any medical advice. But that's the only time that I ever expressed anything that they outwardly expressed to me, we don't like that, and they gave me a warning and then later a strike for that. The two occasions that I talked about it is when the two occasions that I got punished. Never have I ever said a single thing on this channel in the last year and a half, which has basically been something that they said, oh, that's objectionable. That's something that people that, that's dangerous or that's harmful to society. No, never, nothing. They still keep stripping people away every day, 10 people, 20 people. It changes when I have upswings. Thank God right now, I'm in the middle of an upswing that I'm covering Fani and people are enjoying the content. So like I'm in an upswing right now. So maybe they're still doing it every day, anyway, but I don't notice it because they're being outnumbered by people joining the channel. And if you're new here, please, if you could subscribe, I'd appreciate it. But yeah, I can't tell you who's been removed. They won't show that one to me. We Diggers demand Ben to be permabanned from the time. George Erickson hitting me with the 50. When you drop a 50 on me, anything 50 or above, you get one of these. The war horn for George Erickson. Question. Apparently, Nathan Wade was in charge of the selection audit group, the district attorney's office for Fani Willis, early in the process of setting up the DA's office. According to Breitbart, why was this not brought out in the hearing? Oh, that's a really good question. And the answer to that is that the only thing that they fixated on, that he seemed remotely fixated on, because there was a large number of issues that Ashley Merchant, who filed this on behalf of defendant Michael Roman, and everyone else sort of signed on with her. Donald Trump signed on through his counsel, but this was all Ashley Merchant's baby. And she basically said, here are all the reasons that Fani Willis was twisted into starting this prosecution for reasons that have nothing to do with interest, with the interest of justice, and purely about self-interest. And she talked about the publicity and how she goes on these different tours and how he's not really qualified and all these different problems with Fani Willis and Nathan Wade serving in their roles as counselor. And one of the things she mentioned is, and she has this romantic entanglement that she never disclosed to anyone, and she gives this job to her boyfriend here so that she can get money from it. And that was the only one that piqued the judge's interest. And the judge was very, very clear. He's like, I don't want to hear about anything else. That's all I want to hear about. To me, that smells like it could be impropriety. And that's what we're going to have a hearing on. Now, was he correct in reaching that determination? Some would say yes, some would say no. I'm not crazy about that. Between you and me, I'm just on this issue, I'll tell you, between you and me, if you ask me on the Fani Willis thing, like in my heart of hearts, why do I think that she shouldn't be there? It's not because of the romantic relationship. I know it's salacious. I know it's fun to cover. I know it's kind of hilarious. And I know that they walked into a whole bunch of lies out of their embarrassment about how they handle the situation. If you ask me, I just don't in my heart of heart believe that like her main motivation here for going after Trump and all these co-defendants was that she can get a couple $100,000 worth of work over to Nathan Wade. I just don't buy it. Personally, I don't think that's true. Because I think that she has so many other motivations. I think she loved the lights. I think she loves being treated like a superstar by the media. I think she probably hates Donald Trump. So do I think that she's acting in the interest of justice? Oh, hell no. But do I think that the problem with her, that the reflection of her lack of interest in justice is because of her relationship with Nathan Wade? No, I don't think that's the primary thing. I think that when she starts going on these speaking tours and she brings it, I think when she's raising charges that no one thought about actions that Trump took that are purportedly illegal, that at the time he took them, nobody thought this was illegal. But now, because we're trying to go after him, all of a sudden we're just going to reclassify actions that seem like totally natural thing for a president to do and start labeling this as a violation of law that he should spend time in prison for. To me, that's a perversion of justice. That's a blatant perversion of justice. So it's not her behind the scenes stuff that, to me, it shows that this is an ill fit for Fani Willis. It's the charges themselves, which are gross and disgusting, and a perversion of justice. But that is not what moved Judge McAfee. He didn't feel like I felt. Instead, to him, he felt as if this entire romantic entanglement and the issues as far as her ceding money over to her boyfriend under the table without anyone realizing it, that seems like it's going to alert the public into thinking there's a lack of propriety here. And when a judge says, this is all I care about, and you're a lawyer, that's what you fixate on. You feed him as much of it as you can. So that would explain why they didn't invest much time or effort in that. I've never been unsubbed in 2 years on all my channels and do wonder if chat is trolling you. No, I see people. I'm telling you, I see it all the time. People tell me on X, they tell me all the time. I don't know. Maybe you should share your secret with them. Got to record each day who subs so you can keep track of all your future diggers. It's not possible. It's not possible. I think this channel gets censored because of all the goat sacrifice. We really don't promote goat sacrifices. I don't prohibit them per se. I don't prohibit them per se. I read Nick had 104 deadly fever and now it's down to 102. I hope he gets better. Me too. I don't know if that's a joke or not. But if he's sick, I hope he gets better. He's awesome, Nick. I have a feeling you're joking though. Just given content I've gotten from you on him in the past. So, all right, let's get back into it.
So that some voices can be louder than others, or some people can get a boost from what they're getting in the marketplace of ideas. And the only place this court has ever allowed that was in Turner. And I mean, Justice Kavanaugh, you pointed out that one of the key things there was content neutral. But I actually think the critical thing in Turner is that bottleneck or chokehold on the content that went into individual houses. And I think that's what made what was otherwise an impermissible government interest a legitimate government interest in that narrow context. And maybe you could say the same thing. I mean, I don't know if Red Lion is still good law, but that's the same idea that there's like a scarcity rationale. But there's no scarcity rationale in the internet. And this court said that in 1997 in the Reno case.
I'm sorry. Can I ask you about a distinction between two possible kinds of applications of the Texas law? So one is the application that prevents you from keeping out certain speech that you want to keep out. You said anti-Semitic speech. It could be any of a number of things. As I understand it, the Texas law also prevents you also from doing something else, which is suppose you wanted to prevent anti-Semites from posting anything. You know, you just wanted to say that they're a class of people. We're not even going to let them post cat videos. Should we think about that set of applications differently?
I don't think you should think of it radically different.
That's a great question by Justice Kagan. That's a really good question by Justice Kagan. So because someone expresses something that you find objectionable one time, so you're going to make it impossible for people to find anything that they ever say, you're going to basically blacklist them. Do you think that that's okay? And Clement is saying, sounds like from the start of it, no, I don't care. Once they've been deemed to be bad people, let's punish them. You're on the wrong side on this one, Paul.
Differently. I mean, it's a different application, but I think it's the same idea, which is there are some speakers, and I think this is going to be, very few, but there are some speakers where they are so associated with a particular viewpoint that it informs essentially all of their speech, and it also affects the speech of other people
all of their speech
in the forum.
All of their speech, everything they say is now terrible. As soon as you cross into a stratosphere that big tech says, we don't trust you, then as soon as you post, even if you post a cat video, oh, that's also going to be depressed. This is craziness. It's craziness, Paul. Dude.
White supremacist on your speech
stop
forum.
it. Everyone's a white supremacist. Everybody's a white supremacist. Everyone. If you believe the internet, Clarence Thomas is a white supremacist. I wish one of them would ask him that. Clarence Thomas should ask him that. According to the internet, I'm a white supremacist. So, should my cat videos be taken down? That would be a bomb question. That would just be like, make his head explode. That's the problem. The problem is that you have gatekeepers who are they're the ones who are the final arbiters, and they don't even tell us what their yardsticks are for determining good from evil. But we should just trust Paul Clement that they're doing their best, despite the fact that we have so much evidence to the contrary.
And they're posting there. It's going to cause a lot of other people to say, what is that person doing? What's going on here? Why are all the dog photos white?
See? I don't think he realizes what a joke this is. Oh, they got white dogs. Oh, it's only white dogs. It's like, Paul, you're so infused. You're so infused that you see, why why? Paul, you're breaking my heart, Paulie. Paulie, you're breaking my heart here by making these arguments. You're breaking my heart. It could be that maybe the reason you stay is because you do throw money at me. It's funny because all the time I'm shaking my washboard abs. I feel it. Maybe if you want to make sure that you stay subbed on this channel, you gotta just keep tucking it in the waistband. I don't know. It could be just to be on the safe side. Look at this. Do you all think Worcestershire? You think Adrian is trolling me? I don't think she's trolling me. And she throws money at me also. See that? Thank God for locals, or I never get a notification. See, the only way Adrian finds me is because she follows me at goodlogic.locals.com. Goodlogic.locals.com. And turn your notifications on locals. Otherwise, you'll be lost. That's what happens. I'm positive Adrian isn't trolling me here. Never been on stuff from any channel to PSYOP. Well, how do you all explain Adrian?
I mean, it's going to fundamentally change the dynamic on the website. And
they're laughing. Why are all the dogs white? I don't know if he realizes how ridiculous it is, because that's exactly how YouTube seems to operate sometimes. Oh, you got only white dogs there. That's mighty sus of you.
I think a website that's trying to promote a particular discussion has a First Amendment right to exclude those people. And in practice, this is, what is used to exclude sexual predators, which is something, again.
No, it's not. That's got nothing to do with that. That's criminal activity.
That the government can't do, Packingham, but Facebook does, and there's certain other people with just very distinct viewpoints where it's, in a sense, we know the viewpoint.
This is true. Don't expect me to read locals. This is fans' way of saying I'm testing to see if you're going to read locals tonight. He's been hitting me up on locals all night long. Uncommitted D 44,900. I should check on Michigan. Should we check on that? Let's pause and check on Michigan. New York Times pretty good. New York Times, Michigan. Joseph R. Biden. Getting 391,000, 64,000 are uncommitted, with 55% of the votes in. He's saying Biden's going to shift away from Israel because he's going to be afraid of these uncommitteds right here. Probably true. It's probably true. We're seeing that. We're already seeing inklings in that direction. It's a good point. It's a pretty astute point. He's also telling me that I can link it with oral argument. Look at you. Much better. Thank you. Thank you so much, fans. How well did 230 work when we got only fans and Pornhub from it? Yeah. Is 230 severable so court could strike or otherwise objectionable as too broad? No, I don't think that they can. I mean, I don't know. It'd be really rough. It's too broad. It's a rough call for them. It's a tough call for them. Ben is not killing anymore on Facebook. They clamped down more. And it did give us some great memes, the Fani case. That's true. The Call of Booty. This is what he shared with me here on that. That's pretty funny. That is pretty funny. Call of Booty. All right. Let me check on Rumble here. Make sure I ain't missed any all here. We're good. We're good over here. All right. Let's get back in. Should make this bigger so y'all can see.
To exclude those people, and in practice, this is what is used to exclude sexual predators, which is something again that the government can't do, Packingham, but Facebook does, and there's certain other people with just very distinct viewpoints where it's in a sense we know the viewpoint is problematic, even if the particular post is not.
But Mr. Clement, I just wanted to follow up on that because it seems to me that Justice Kagan's question kind of gets to the distinction in 303 Creative between turning people.
I like the way they highlight her face when she's talking. That's pretty cool. That's a nice touch. Thank you so much for sharing this with me.
People away and the speech that you have. And so if you think about it as silencing someone who.
How many channels have I been unsubbed from? I don't know. That's a really good question. I don't know how many channels I've been unsubbed from. If you have fever 104 and you go away to tell us you couldn't stream, I would think you may be lying. I think I probably would tell you if I had 104. I probably would tell you. The reason I would tell you that, or Nick would tell you that, is because you understand that people count on you to open up. And I talked about this the other night, that part of the attraction for people to come here that goes well beyond me is you, the chat. I recognize that most frequently, the chat will be discussing what I'm discussing, but frequently there'll be whole conversations that are going on there here or in locals or Rumble, whatever, which has nothing to do with what I'm talking about. And that you guys just actually form genuine relationships with each other. And in that sense, people who are podcasting on a nightly basis are basically opening up a bar like Cheers for everyone to come in and hang out with each other. So if we don't open by having a stream, it's like you have nowhere to go. So in that sense, I feel a proud responsibility in streaming. I was explaining this to my daughter's new father-in-law last night. I was explaining this to him, that it's basically that I'm Sam Malone, and I'm just opening up the bar here, and occasionally having fivers thrown into my waistband. So I can understand how someone who bills himself as being a nightly podcaster, which he is, like you sort of feel like people are expecting me to open. And if I'm not, even if 104, I'm going to tell them I'm not. So at least they have a heads up, and they're not, they basically can make alternate plans. Seems like conservatives 20 years ago were pro-corp and anti-government. Oversight, including corp speech. We were wrong back then. We face a SCOTUS skeptical government regulating corporate speech. Thoughts? Conservatives 20 years ago were pro-corporation, anti-government. Yes, that's true. Oversight, including really more 30 years ago, but still true. Oversight, including corporation speech. We were wrong back then, but we face a SCOTUS skeptical of government regulating corporate speech. We do face a SCOTUS slowly. I mean, the America First movement, and really, this is really over the last 7-10 years that we start recognizing just how bad the government is in trying to regulate speech. I'm not sure what exactly beyond that. I think I agree with a lot of what you're saying. Definitely, and I've talked about this a bunch of times, how conservatives have changed dramatically. In the 1980s, we all trusted government as being good and virtuous, and America is good, inherently good. Whatever we do is good. When we go to war, it's true. Even into the early aughts, it's like, no, we're the good guys fighting against the evil. Whoever we're fighting against must be evil because we're the good guys. We only fight against evil. And there has been an awakening over the last 10-15 years. That's just not always true, and it's not always. And we were wrong for making that assumption about our government. Joe's Place. Well, you call it whatever you want. You can call it the following. That's what I call it.
You let on your platform, then that seems more like speech or content moderation to the extreme, for example. But I assume that the implication of your answer to Justice Kagan is that you could tell the anti-Semite, we're not open for business to you, right?
You can tell that person that our speech forum is not open to you. And I think that's what makes it different, that Texas is focused really on these speech-oriented platforms. And so I think if you're in the business of speech and you have somebody, and again, this is not sort of other prohibited statuses, this is viewpoint. And so you are a notorious anti-Semite. We do not want you to participate in this conversation.
Religion, then.
Sure, and I want to have a Catholic website. I can keep off somebody who's a notorious Protestant. I mean, I want to preserve the nature of the discussion on my forum, and it's a private forum, and the government can't tell me, as a private party, let the Protestant into the Catholic Party. I don't think so.
Mr. Clement, can I ask you about Section 2? I don't think anything has been said about it so far. So you say that Section 2.
This is Section 2 of House Bill 20. That Texas had. So just to point out to you, we pulled up here the section, the bill here. So if we look at this bill, Section 2, the portion of Section 2 that they had an issue with was requires platforms to disclose how they moderate and promote content, which means basically having transparency as to who it is that they're shutting down.
Whose individualized explanation requirements violate the First Amendment because they impose a massive burden, right? That's your argument? I mean, it seems to me that the European Union has imposed exactly the same, pretty much the same individualized explanation requirement on anybody who operates there.
Get him, Alito.
Texas has
imposed,
and I'm not saying that whatever the European Union says is okay is constitutional here, but just on the practical question of whether it's too much of a burden, if it's not too much of a burden for your clients to do it in Europe, how can it be too much of a burden for them to do it here?
Great question. Great question. You're saying practically, as a practical matter, this is way too much of a burden, but we're happy to do it for Europe. We just won't do it for Texas.
So as I understand the requirements, they are different. They're materially different. This, and in a sense, the European Union provision has sort of a built-in kind of, reasonably practical provision right into what you have to do. You only have to do what's reasonably practical. This is an absolute requirement to respond to every takedown, and that's over 1 billion takedowns of comments in a quarter for YouTube. And then there's also this appeal process.
1 billion takedowns. Do you hear yourself? 1 billion takedowns. 1 billion. 1 billion.
Which I don't think is coextensive with the process in Europe. So just as a practical matter, I think this is more burdensome. But as you said, the First Amendment does not apply in Europe.
Yeah, but your argument is not that. Your argument is that it's First Amendment and it's impractical, but it's not impractical. So let's carve out the whole impractical, because you managed to do it for, you managed to figure out how to do it for Europe. You can figure out how to do it here. So you're trying to sort of hedge these together, but that's not hedgeable, because clearly you can do it for Europe. You can do it for Texas.
And I think that having this kind of disclosure requirement on what is really an editorial discretion decision is potentially, hugely problematic. If you took this and said, the New York Times, you have to tell us why you rejected my wedding announcement. You only take like 10% of the wedding announcements. You have to tell me, even if you automized that and sort of said, well, one, if, you weren't rich enough, two, if you weren't connected enough in New York social circles, and three, we just didn't like the way you looked. Even if
your
you automated
client,
that,
some of your clients are humongous, and if you want to say this is unduly burdensome, then you have some obligation in the district court to try to. It's enough for you to just say this is a huge burden, so knock this out. Well, didn't you have to provide something to show what resources would be required?
That it wouldn't be like, let's say, 1% on an annual, 1% of your daily take to cover it annually.
we did.
And why that would be too much for these megaliths?
We did. There's more of a record in the Texas case than in the Florida case. The witness for YouTube in their declaration specifically said this would be 100 times more burdensome than their current process. And so there is a record on this. It isn't.
That's not really 100 times. Sounds like, I don't believe it's exactly 100 times. That sounds like someone who's speaking hyperbolically. That's not any sort of evidence. That's just an offhand remark. Oh, that'd be 100 times more. You could have said 1,000 times. You just threw out a high number. That's not evidence. You know better than that, Paul.
Incredibly burdensome.
Justice Thomas, anything further? Justice Alito?
The 230 argument is intriguing to me, and it's the distinctions that you're drawing somehow, to some degree, escape me. So is it your position that you are exercising editorial discretion as to everything? Let's take YouTube. As to every video that is placed on YouTube, you have exercised editorial discretion that you want that on YouTube?
I would say that we have exercised some editorial discretion to not sort of eliminate that from the site entirely. And as to an individual user, we've used what are typically, in many cases, neutral algorithms.
Not in my case. Not in my case. Ask Adrian. Adrian! 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 Ask Adrian. Where's Adrian? Where's Adrian? People tucking money in my way. Adrian tucking money in my waistband. No, she ain't. I guess that was Worcestershire. But Adrian does too. Adrian! That's pretty good. That was pretty good. Adrian! I'm a podcaster now. Adrian! I'm a podcaster! Come out. I feel all bloodied from YouTube. I've been coming back from my battle with YouTube, boxing it out with them. Adrian! They just held up, the ref just held up YouTube's hand. I look over at Apollo Creed. Come find me, Adrian. Come find me somewhere. Come to locals.
But some of them are not neutral. And even in Tomna, the briefs, I think, made quite clear that, although that at a certain point, some of the algorithms were neutral as between rice.
Wait a second. Wait a second. Really? You didn't get the reference? You didn't get the reference? Really? Really? Come on. Come on. Come on.
Peel off in terrorism. There were other efforts to affirmatively get terrorist stuff off of those sites. And so there,
if you were a newspaper and you published the content that appears in every single one of the videos on YouTube that you allow to be included, you would be liable potentially for the content of that material. And I don't understand the rationale for 230 if it wasn't that you can't be held responsible for that, because this is really not.
See, it's not just me. I'm one manifestation of the problem.
Your message. Either it's your message or it's not your message. I don't understand how it can be both. It's your message when you want to escape state regulation, but it's not your message when you want to escape liability under state tort law.
Nice. Get him. Get him. Ugh. Gotta love Alito. Gotta love Alito. Big social media hired Paul, one of the best SCOTUS lawyers, yet we get this weak sauce. Well, they did. He is one of the best SCOTUS lawyers. Guys argue more than 100 cases in front of SCOTUS on a first-name basis with all these justices. Fortunately, it doesn't sound like he's doing that well.
So I don't really think we're being inconsistent, and what I would try to draw the analogy just to a good old-fashioned anthology. If I put together an anthology of 20 short stories, everybody understands that the underlying short stories are still the product of the of the individual author, but as the anthologist, as the editor of this compilation who decided which 20 got in, which ones didn't, I'm responsible for those editorial discussions, those decisions. Those are both protected First Amendment decisions. You can distinguish between the underlying material and the editorial decisions. Now, at common law, the publisher was responsible for both. And so they were still liable for what the republishing the author's work. And that's precisely what Congress wanted to get rid of in 230. And they wanted to essentially give our clients an incentive to weed out of the anthologies the stuff that was harmful for children and problematic. And that's why I don't think it works to say, oh, well, then that's your speech, so you're liable under 230, because it's that editorial control, the weeding out the bad stuff. That was the whole point of 230, to empower that.
I don't know how a publisher could be liable for, I take that back, for fiction. But certainly if it was, I mean, if you, back in the day when some written material was considered to be obscene, you put together an anthology that included obscene material, you could be sued. Today, if you put together an anthology of essays, nonfiction writing, and there's defamation in there, then the publisher could be sued. Even the publisher, we exercise editorial discretion. That doesn't shield you from liability.
Not at common law, and that's why Congress had to come in with 230. But what Congress did is it looked at the common law and it said, oh, this is problematic. Because the only way you can avoid liability at common law is if you act as a conduit and let everything out. And once you start keeping out a little bit of porn, then you're responsible for the porn that slips through. And that's not practical on the internet, and that's why we have 230.
Right, I don't want to belabor the point. Let me just say something about the analogies that both sides draw to the issues that were presented in prior cases. So you say this is just like a newspaper, basically. It's like the Miami Herald, and the states say, no, this is like Western Union. It's like a telegraph company. And I think I look at this and I say, it's really not like either of those. It's worlds away from both of those. It's nothing like a newspaper. A newspaper has space limitations. No matter how powerful it is, it doesn't necessarily have the same power as some of your clients. But put that aside, newspapers overtly send messages. They typically have an editorial. They may have an editorial 365 days a year or more than one. But that's not the situation with even the most prominent of your clients. So I don't know how we could decide this case by jumping to one side or the other of this case law.
Well, Justice Scalia, let me offer two thoughts. One, this isn't the first time you're wrestling with the internet. You wrestled with it in Reno. You wrestled with it last term in 303 Creative. And I think the gist of those cases is this is more like the newspaper or the parade organizer than it is like a common carrier.
No.
And then as to the cases, whether you think that this is different from a news.
The point to a common carrier, for those of you who are confused, is that a common carrier can't say we don't like you, so we're not taking you. They have to take everyone. They can't say we don't like you because you're white. They can't say we don't like you because you're black. They can't say we don't like you because you're racist or because we're racist. They just have to take everyone. That's the point to a common carrier. Phone company can't say we're not going to hook up your phone because we're worried you're going to start spreading all sorts of anti-white or anti-black messages. They have no right to do that. They have no ability to do that. That's the point. And if they're treated as common carrier, in that case, common carrier meaning that they're basically part of they're part of the infrastructure here. Well, in that case, they don't have a right to pick and choose who their clients are. And that's what a lot of people are saying is a way that you can sort of keep them from being able to discriminate. All of a sudden, it's like, oh, we don't like your messaging. Imagine all of a sudden your phone starts cutting out as soon as you start expressing opinions that AT&T or Verizon don't like. They don't have that right. They don't have that ability. It also would be really unsettling.
Newspaper. I mean, the arguments that you're pointing to say this is different are the arguments that those cases wrestled with and said didn't matter. So I know you know this, but in Tornillo, there was all this language about it being a monopolist. And that was in the context of a local political election, where if you couldn't get into the Miami Herald, where else were you going to go? And yet this court said that didn't matter. And also in Tornillo, this court said, yes, space constraints, there are some, but our decision doesn't turn on that. And then in Hurley, there's a lot of language in the court's opinion that says, this is not much of a message, and they let some people show up even if they get there the day of, and the only thing they're doing is excluding these group. But of course, the exclusion was the message that they were sending, and it's the message the state was trying to prohibit. And that's kind of the same thing here, which is
if let's say YouTube were a newspaper, how much would it weigh?
Well, I mean, it would weigh an enormous amount, which is why, in order to make it useful, there's actually more editorial discretion going on in these cases than any other case that you've had before you, because it's people tend to focus on the users that get knocked off entirely and end up on the cutting room floor. But both these statutes also regulate the way that these social websites they sort of get you down to something that's actually usable to an individual user. And in fact, if you tried to treat these entities like a true common carrier, so first in, first out, just order of, you'd open up one of these websites and it would be gobbledygook. Half the stuff wouldn't even be in a language you understood. And even if you controlled for that, you'd get all this garbage you didn't want.
All right, thank you.
I'd like to go back to the individualized explanation requirement.
I'm very curious to see where the left falls on this, because this does seem, the argument that I'm advocating seems, it's a little weird. Because if you think about it, imagine the internet was exactly 180 degrees in the way it is now. You'd be positive that Sotomayor would be sitting here saying Texas, the states can do whatever they want. They tend to go along with the states and government power. So I'm very interested to see how the left side of the bench leans on this whole thing. I already saw Kagan, where she seems to not really love Clement's position here, which is a good thing.
And please remind me, what did the district court do here? Did it grant you an injunction here?
It did.
Yes, the district court granted an injunction, and then the circuit court overturned it. Seriously. Someone told me Sonia Sotomayor is brilliant. You don't even know what the district court did? Come on. Make notes to yourself, honey.
It was the circuit court who didn't.
Yeah.
So it was a district court who looked at the amount of material you submitted. And I know your declaration, YouTube said it would be a burden 100 times more than it does now.
Oh, I see where she's going. Eventually, much like Linda Richards, Sotomayor and I will be on the same page on something. But it seems, alas, that today is not that day.
I don't know what the quantification of that, whether that was quantified or not. Was it, 100% more, 100% more
100%.
costly, 100% more what?
100% more of its current effort, its current sort of, efforts that are dedicated
but
to.
we still don't know what the cost of that is and what.
Yeah, I mean,
there's a lot of unknowns, but this was a facial challenge with respect to that. And Texas seems to say you don't need to do much. You just need to have the computer spit out 1 through 10 reasons. And if you have a few individualized ones, you could just explain those individualized. What do we do with that dispute?
so first
Because
of all,
it is a facial challenge.
it is a facial challenge. It is a preliminary injunction. We've obviously been over some of that. There wasn't just declarations. There were depositions taken. There was a record that was put together on all of this. And Texas was taking a slightly different view of what the burdens of of Section 2 were there. And so I think on that, if you just look at the record that was before the district court, you should affirm the district court's preliminary injunction. What I would say, though, is I also think that even what they say on page 44 of their red brief is that, you can do this in a relatively less burdensome way as long as your editorial policies are sufficiently specific and particularized. And what they're basically saying is, you could change your editorial policies a little bit to make it easier to comply with this disclosure obligation. And that seems...
That begs the question, right?
Yeah, exactly.
Because they're affecting, okay.
Mrs. Kagan?
I just have a quick question. So part of the dynamic that I think is going on in these cases is the fact that this regulation is enacted by the sort of democratically elected representatives of a state. And I suppose that if the state's regulation of these platforms gets too burdensome, then presumably the platforms can say, forget it, we're not going to operate in your state, and then the citizens of the state would have the chance to determine if that's what they really wanted. That's sort of how I'm looking at this at a meta level. So what caught my attention was your response to the Chief Justice when you suggested that your client couldn't withdraw from the state of Texas because you read the provision related to censorship and geography as ensuring that you don't do so. I had not read that provision in that way. So can you say more about why that's your interpretation?
So the question here basically is, as far as understanding the statute, does it enable them to say, okay, look, if this is what you're going to make us do, we're just not going to operate in the state of Texas. I don't know how they couldn't do. I don't know why they wouldn't be able to do that. And that's how Ketanji Brown Jackson understood it that way. And she's understanding his answer as implying that they're obligated to keep providing service in Texas and to comply with Texas's new standards. It's an interesting question she's asking.
Sure. I think that's the obvious interpretation of that provision, particularly when it talks about, this isn't like, don't discriminate against Texans or Texans wherever they are. The fact that it's particularly preventing us from discriminating on somebody with a geographic location in Texas is basically telling us that we can't try to geo-fence our service and try to essentially, explain to the people, sometimes like if you get your cable service has a dispute with the provider and you can't get your football game and they tell you if you're hacked off about this, call this number and complain. We can't do that in response to this law. And I think the legislators in Texas were able to tell their constituents, don't worry, if you like your website, you can keep it. We're not going to threaten. They can't pull out of here based on the way that we're regulating them.
So even if we could read it a different way, you're saying that this necessarily, I guess this also dovetails with my concern about us not having sort of state interpretations or an application here to really understand. Because I could read this differently. It seems to me it's fitting into the whole set of things you're not allowed to do. You can't censor people on the basis of the viewpoint of the user. You can't censor them on the basis of the viewpoint that is being expressed. And you can't censor them based on their location in your state or another part of the state. And so I guess I don't necessarily see that in the same way. You can't just automatically do that, I guess. I don't know.
It seems to me quite clear that it's designed essentially as a poison pill, or somebody described it as the Hotel California provision, that you can't leave Texas even if you want to try to do that as a way of showing that this is an impermissible way of regulating our expressive activities. And, so I do think that is the right reading. I do think the fact that it's geographical location in Texas is kind of a clue to that. So this is not something where, if you're a Texas fan, you're protected no matter where you go in America. This really is designed to sort of say that you can't do the kind of geofencing that you might otherwise do to comply with an idiosyncratic state law. I should mention, just for the sake of completeness, that, in the lower courts, not part of the preliminary injunction, there are dormant Commerce Clause challenges to these provisions and the way that this is just kind of one state trying to regulate everybody. And so that's part of the case that will be there.
But it's not here yet.
But it's not here. All that's here is a preliminary injunction that runs to my clients. So, this statute has a smaller universe of people, but if there's somebody else out there who, isn't one of my clients, who isn't covered by this preliminary injunction, the statute could take effect as to those people, and the same is true in Florida.
Thank you.
Thank you, counsel.
I think Jackson actually asked some good questions there. And part of the point she was making is, because we're at this preliminary state, it's a little bit difficult for we as the Supreme Court to actually know how the Texas state courts will interpret this statute. They may interpret it to say that Facebook and YouTube have to keep doing business in Texas and to comply with the law, or they may interpret it as the way Jackson interprets it, which is YouTube, if you don't like it, leave Texas. Just don't service Texas. In which case, don't do it. That's not nothing wrong with that. No one's telling you if Texas is a place that you can't do business economically, don't service them. So, and we don't know whether or not. And Paul Clement is like, well, that's not our interpretation. Our interpretation is we must keep opening up for business. I don't understand how he has that interpretation. I haven't gone through the statute line by line. It seems a little weird to say that that's part of the claim that Texas is obligating big tech to keep operating in their state. Like, how can they obligate anyone to do that? They're simply saying, if you are operating, this is what you have to do. To me, that's how Texan court is likely to interpret it. But until they do give that interpretation, so the Supreme Court is basically put in a position of how are they supposed to sit here and know which way it's going to be interpreted and applied. This statute will be applied by the state of Texas. Those are fair questions that Jackson was asking. This case is bringing out the best of some of these Supreme Court justices. Sotomayor, not so much, but, We're seeing good things from Kagan. Jackson, good questions. Good questions going around here. I'm liking it. Alien News says, on Twitter, I do first install. I sub to who I want, put on follow, only tab, and get what I want. News at the moment. When I go to algorithm tab, I get a bunch of crap I don't follow. The old algorithm. Yep, that's what I get too. All right.
General Preliger.
Mr. Chief Justice, and may it please the court, I want to pick up with the question that Justice Alito asked in the seriatim round to my friend about the idea that the social media platforms don't perfectly fit into either analogy or paradigm here. And I want to acknowledge the force of that intuition. They obviously operate at a massive scale that goes beyond any particular parade or beyond any particular newspaper. I think the right thing to do with that intuition is to recognize that it's not like you can just exempt them from the First Amendment. They are obviously creating something that's inherently expressive and taking all of this quantity of speech on their websites and curating it and making selectivity decisions and compiling it into a product that users are going to consume. So the First Amendment applies, but I think that those kinds of concerns about how the social media platforms and how they look somewhat different from the other kinds of expressive products this court has reviewed in prior cases can come into the question of whether the First Amendment is satisfied with respect to any particular regulation.
I'm going to tell you right now, so far, Solicitor General Preliger sounds highly competent. Highly competent. It sounds like she was listening very closely to the questions that were being asked to Clement and the responses, and that she has some thoughts of her own that she wants to weigh in with, and she sounds highly competent so far. Hopefully she keeps it up because I'm on her side here.
Now here, we think it's not satisfied because of the way that Texas has designed this law. I'd urge the court to rule narrowly. It's not necessary here to try to figure out how the First Amendment applies to new technology in general or to every possible website or the internet in particular. This law has a very clear defect. What Texas has done is try to countermand.
Maybe I don't agree with her. She still sounds highly intelligent.
The protected editorial speech decisions of the platform, and the only justification it's offered to the courts below is that it wanted to essentially amplify the voice of users on that platform by suppressing the platform's own protected speech. That is a defect that is clear under the First Amendment, and the court could say only that and resolve this case. I welcome the court's questions.
General, when I asked you about the difference in treatment of private party as opposed to the government engaged in similar conduct, your answer was, of course, that it would be different. The government would be bound to comply with the First Amendment. There was some discussion in a number of the amicus briefs about instances in which the government and the private party, say petitioners here, and the government coordinating efforts. How would you respond to that?
Meaning you want to make a whole distinction based on the fact that, well, these are private companies, they're not government companies, so we don't have to, they're not governed to recognize the First Amendment when it comes to these conservative viewpoints. And Justice Clarence Thomas is like, hey, we got a lot of claims here that these megalith companies are working hand in glove with these big companies. So maybe they're not so different. So what are your thoughts on that?
So let me respond to that by saying I think the position we're offering here and the position this court will consider next month in the Murphy case are entirely consistent. We, of course, acknowledge that if the government actually coerces the platforms and takes over their editorial decision-making, then the platforms could be deemed a state actor, and that would be subject to First Amendment scrutiny. We vigorously dispute that that has actually happened.
Oh, please. Thousands and thousands. How many thousands of hours are spent each year with the government saying, take this person down, take that person down, more than 90% of which is quickly obeyed by big tech. Stop it. Just stop it. Who are you trying to kid? Called the worst First Amendment abuse in the history of our country by Judge Dowdy in Missouri v. Biden. So stop it. Vigorously dispute that actually happened. You can vigorously dispute all you want, but you're just now you're just tilting at windmills.
And the federal government has engaged in that kind of coercive conduct, and we further dispute the legal standards that were applied in that case. But there's no inherent tension here. You know, the federal government obviously can act and criticize the social media platforms' content moderation decisions. That's just using the bully pulpit to express views. And if the states disagreed with how the platforms were exercising their content moderation standards, it could have done the same. It could have criticized them. It could have urged them or tried to influence them to adopt separate standards. But here, what the state did is said, we're going to pass a law that actually takes over their content moderation and dictates that it has to be done in a different way.
General, Texas.
Before we get to her question, before we get to Judge Kagan, from the last stream about questioning versus why and what. Okay, I'm glad you asked me this question because I meant to get back to this. I want to just take a moment away from this case here of NetChoice versus Paxton and talk about this. I tried to timestamp your ass wrong, but upon further consideration, I think we could have gotten the defendant to say, I don't know, more times. Okay, I'm glad you brought this up. I'm telling you, I've seen in the comments how a lot of people are like, no, here's timestamp at 1:33 or 1:30, and meaning an hour and 30 into my stream, where these questions were asked by Sado. Okay, I know that Sado kept yelling at him. Why did you do it? Why did you speculate? Well, I basically, in case you missed that stream, which I doubt that many of you did, because I had a lot of people watching that, probably 4 times as many watching that as are watching right now. So I assume that most of you watched that stream, but you might not. You might be one of the few who didn't have a chance to review it yet. So I will tell you that I was highly critical of the fact that all of these defense attorneys, when they got up there and they started pinning him down, pinning Terrence Bradley down, this is Nathan Wade's attorney, and saying, you told Ashley Merchant that absolutely the relationship between Nathan and Fani began well before he signed a contract with them. And now he's like, then on the stand, he said, I don't know when it actually started. And when he was shown those texts, he says, I was speculating. And they kept saying, why? Why were you speculating? Why? Why were you speculating? Why were you speculating? He's like, I don't know. I just did. I don't know. I just did. I don't know. I just did. Wording the question when you have someone who's being particularly evasive, which he obviously was, bending over into contortions, trying to be evasive, like a man who was terrified of actually opening his mouth there, as if the mob actually had guns to the heads of his children if he said the wrong thing while sitting on the stand. That's how evasive he was, highly evasive. They kept saying, why? Why did you speculate? Why on that did you speculate? That's the only thing you speculate. Why did you choose to just volunteer that information out of the blue? Why did you speculate? That is not the same question as how did you reach that speculative conclusion? It is not at all the same thing. And just screaming it louder, which is what Sado basically did, is not the same question as how did you reach that conclusion? Because when you ask the question, why? In fact, you know what? I'm even going to pause. I'm going to pause and actually pull it up because I saw people timestamping me. I'm like, I don't know what the heck you guys are talking about. You don't know what you're talking about. I have no idea what you're all talking about. It's 3 minutes. 3 minutes, which I keep getting hit. I keep getting hit on. We're going to go through those 3 minutes, and you'll see that I was right. Here we go. Here we go. This is it. David Whitten was all over me on this, as were several others. And he said, maybe in your own words, why the heck would you speculate in this text message and say that started when she left the DA's office and was a judge in South Fulton? Okay. I knew that they met municipal court. How did you know that? Back and forth. Then again, how did you know that? All right, let's watch it. This is all happens in a span of 3 minutes. We'll watch those 3 minutes. I want you to listen for a single time when they say, what evidence did you have that brought you to have that particular speculation? Because why did you speculate means why did you bother typing that out to Ashley? That is not the same thing as when you type that out to Ashley, what factors led you to that conclusion? Meaning, you could have chosen not to speculate. The first question is you could have chosen not to speculate, but you chose to engage in speculation at that time. If you're being evasive and the state is going to argue, and I can promise you, the state will look at that and say, oh, he's explaining why he decided to do it. He said, I don't know. I just was in the mood to speculate at that time. But that doesn't tell us how he came to that conclusion. If instead you said, did you see them ever holding hands? Did you ever see them hugging? Did you ever see them kissing? Did you ever see them giggling at each other, giving each other googly eyes, things of that nature, and you get very specific with him. Were you thinking about times like that? And that's what helped lead you to a conclusion that they were a couple. Now you start evincing specific things as to what was going through your mind that said, given all of these things, I have a feeling they're a couple, as opposed to, given all these things, this is why I'm going to type out something. I'm in the mood to type out something. Why did you type it out? Oh, that's not a question. That's not relevant. That's not eliciting specific behavior by Wade. It's not eliciting specific behavior by Fani. You want to elicit what specific behavior he observed or heard about that brings him to have a thought that ever crosses his mind, a speculative thought of they are a couple. But instead, when you hit him on why did you speculate? Why did you speculate? That does not the same question as what factors brought you to that conclusion that you speculate about. In fact, let me make it a little simpler. You start with this. You use the term speculation a lot. How do you define speculation? And then you get him to basically define speculation as something along the lines of that I look at different factors and I come to a conclusion. And then you say, perfect, great. Or you could say Merriam-Webster defines speculation as this. Is that what you meant when you said the word speculation? Let's pull up Merriam-Webster here because a lot of people seem very confused about what's happening here. Speculation. Webster. There we go. To meditate or to ponder a subject, reflect. So what were you reflecting on when do you agree? Was that what you meant when you said you were speculating? Yes. So what were you meditating about? What facts or what had you seen from Fani and Nathan that you were pondering about, which brought you to that conclusion? Not why did you type out words to Ashley? Why did you engage in the act of speculation? It's what happened that came to this particular conclusion in your speculation. I don't know why this is so confusing. Good afternoon, everybody. Welcome to Good Logic Today. We are going to be
in this text message and say that it started when she left the DA's office and was a judge in South Fulton. Why would you speculate and say that in a text?
Why would you speculate? Meaning, why are you engaging the act of speculation? That's how that easily could be read. Maybe he meant it as what brought you to that conclusion, but I don't know that that's what he's asking. Good.
I knew they had met at the municipal court conference.
How do you know that? I'll stop you right there. How did you know that?
And this part I liked.
I answered that at the last.
I'm asking
I knew
you
that.
now.
I knew
Sir,
that because
I'm asking you questions, and you are in a situation where you get to give answers. I'm asking you, how did you know that?
How did you know that they met at municipal court? What you told me.
How did I know when they met?
Somebody told you that, right?
When they met?
Yeah.
Yes, correct.
Who told you?
Mr. Wade told me when they met.
So you had more than one conversation about the relationship between Mr. Wade and Miss Willis because he told you where he met her.
Good.
That's incorrect. Incorrect.
It's
ask him when. Okay, so I think the judge cuts him off when he asks.
incorrect.
It's incorrect.
Okay. Let's go back to the exhibit. Why would you speculate that that's when they started the relationship? What would cause you to put that down as speculation?
Okay, that's closer. That's definitely a lot closer to the question than I remembered him asking. To be fair, that is a lot closer. Let me hear that one more time.
Let's go back to the exhibit. Why would you speculate that that's when they started the relationship? What would cause you to put that down as speculation?
I
don't know.
Don't recall, but why I thought that it started at that time. But I do recall that he only met her, and I testified to that he met her at that conference, which was
okay. That's closer than I remembered. I'm not going to kid you. That's closer than I remembered.
In 2019.
You knew that Ashley Merchant represented a defendant in this case when you were text messaging with her, correct?
Yes, I did. Yes.
And you knew that the reason she was asking you questions about Mr. Wade was because she was trying to show when the relationship began, correct?
No, that's not
It's not.
100%
What's the beginning of
correct.
the text message?
We're almost done here. He's doing a good job drilling. This is a good job.
Yes,
of
but
pulling
what
him in.
messages were before this message? Before
This
she
is
said
well
that?
done.
I can't answer that question because I don't have them. All I have is what's in front of you. And
Yes.
it says that she says, do you think it started before she hired me? So you knew, as the counsel for a defendant in this case, that Ms. Merchant was asking you specifically about the knowledge that you had regarding the timing of the relationship between Wade and Ms. Willis, correct?
Not exactly.
I mean, based on this, yes, I see
And
what was asked.
And in response to that, you answered directly on your own what you now claim to be speculation, right?
That's correct.
So I ask you one more time before I move to the next part of this. Why would you speculate?
Why would you speculate? See, it's so can be interpreted two ways. And I don't like giving him an opening to interpret it the wrong way. That's what's bothersome to me. I don't like the fact that he gives him an opening to interpret it in a way that is meaningless, as opposed to pinning him into answering the question in a way that must be meaningful.
When she was asking you a direct question about when the relationship started.
I have no answer for that.
See, that question really is, why would you start playing in the game of speculation? Not a question of how did you reach those speculative conclusions? And that's questions that you could have definitely, he definitely could have hit on, and he never got there. He walked up to the line of where I want him to go. I don't feel like he actually crossed that line. By asking him, had you seen them holding hands together? Had you seen them sending love notes to each other? Had you seen them? Had he told you that he's going out for dinner with her? There had to be different things that led you to reach that conclusion. What helped you reach that conclusion that was your speculation? It's really that simple. And we don't have that. Instead, we have this thing of like, why would you be doing speculation? Let's put it this way, okay? I'm just gonna put it one final way. Maybe this will walk you through it. Imagine he never actually wrote out the words to Ashley Merchant, but instead, that speculative thought went through his head that day for one reason or another. He's like, I think Nathan and Fani are going out. I think they're dating. Long before Wade actually tells him about it. So what are the factors that lead you to reach that conclusion? Not why are you sending this message to Ashley Merchant? No one cares about the fact that he sent it to Ashley Merchant. It's the fact that what factors lead you to come to that conclusion, Sherlock? You put together all these clues and figured out that they're a couple. What clues were you putting together? It's really that simple. What are the clues you're putting together that say, this leads me to conclude that they have a relationship? That's what you want to know. Not why did you bother? Why would you sit there engaging in speculation when she only wants fact? Which is a whole separate thing. And I think he can interpret it, or the state can interpret it as that's what he was addressing this entire time. As opposed to nailing him down, clues by clues by clues. Did you see them touching each other in ways that only people who are dating would touch each other? Did you see them talking to each other in ways that only people who are dating would talk to each other? Did you see them having frequency of conversations that would only be conducted by people who are actually a couple? Very, very specific, detailed things that you would expect that's probably what he saw, which led him to come to that conclusion. That's what you ask him about. I don't know how many times I got to go through this. Is it interesting that SCOTUS didn't need to speak legalese? Is it interesting that SCOTUS don't need to speak legalese to each other? Maybe it's because of diversity hires. I was watching Robert Gouvet in case you were sleeping. You see, what the heck? This is so rude. A couple of people were speculating that maybe I'd be sleeping. Why the heck would I be sleeping? And this right here is why I love Joe. Thank you. Thank you. I'm not sure what it is, but I was being serious. Having to say, I don't know, it's more specific questions would have been more effective. Sorry, Papa. No, I'm not upset with you. A lot of people were critiquing me on this, and I still feel that I'm right. He never fully vetted it home to, like, there has to be something that was going through Bradley's mind. Something was going through his mind that led him to come to that speculation. And those are the things that we want to know about. That's exactly the things we want to know about. I think Joe saw what? What bone? I don't know what that means. On what knowledge did you base your conclusion? There you go. There you go. There you go. Perfect way to word it. Perfect way to word it. Precisely. Which is not at all, why did you speculate? Why did you speculate is like, why did you go to the bathroom? Why didn't you finish your homework? It's not what was in the homework. Haven't been around since Mindset started streaming VTuber drama. This is a weird rabbit hole. You have any interest in said subject? Congrats to you, Coleman. Oh, Coleman's around? Yeah, I know he's doing his whole. I can't explain why people are care about VTuber drama. So no, I'm not really interested in it. I don't know very much about it at all. This is a question again. The way you're wording this question, is as to why he's engaged in the process of speculating. I don't care about why he's engaged in the process of speculating. I'm only saying that if you actually were just speculating, something led you to that conclusion. So what was it that led you to that conclusion? What, as Janelle said, what facts are you basing that speculation? In his text, he did not use, I believe, was declaratory statements only. Yeah, okay, that's fine. This is all fixating on what he wrote in text. I don't care about that. I care about what was going through his brain the second before he sent the text. What factors led him to that conclusion? Assuming he was speculating. Let's assume we want to pretend that we believe him for a moment, which obviously no one does. But if we want to pretend we believe him, still some factors have to be going through his head that leads him to that conclusion. What are those factors going through your head? I really don't feel that question ever came out. People are saying I'm being too ticky-tacky and critiquing the attorneys on this. Look, I've been effusive in my praise of Steve Siddall, and I still think he's a great attorney. Great attorney. I'm not taking anything away from him. I'm simply saying I don't feel like they nailed this down as effectively as they could have. Can I get back to my job? I'm not even halfway through here. God, I'm 2 hours in.
Texas's law, even more than Florida's, can be understood as an expansion of public accommodations laws. And the United States is often in a position of defending public accommodations laws and insisting that they be vigorously enforced. And how do you see what Texas is trying to do as consistent with that broader stance about public accommodations laws?
Yes, so I want to be very clear.
Yes. Thank you, Janella. He did ask how, he asked why, he asked when, but he never asked what was going through your head. What had you seen? What facts did you see? What situations did you see? What was told to you that led you to that conclusion? What was told to you that led you to that speculation? What observations did you make that led you to that speculation? Never once asked what.
And stake out potentially some separate ground from my friend representing the platforms in this case. With
really great job, Janella. Thank you.
Respect to generally applicable public accommodations laws that protect based on a particular status. We think, of course, those laws are valid on their face and that they serve compelling governmental interests. And so to the extent that you're looking at how an ordinary public accommodations law operates, the refusal to deal, the refusal to serve, as Justice Barrett said, we think that's a regulation of conduct, and that ordinarily there would be no First Amendment problem with the application of that law. Now, I acknowledge that it gets more complicated when those laws are applied to a business that is providing an expressive product, and cases like Hurley or 303 Creative show that in certain applications, sometimes the public accommodations law has to give way to First Amendment interests. But I think the court has drawn a clear line. It has never suggested that the mere refusal to deal or serve based on status, even with respect to an expressive association, would fail under First Amendment scrutiny. Instead, you look at a case like 303 Creative, and there the concern was about changing the message. Or a case like Hurley, gay and lesbian individuals could march. You just couldn't change the message by holding up a particular sign. So we recognize that there are going to be some applications where you'd have to conduct that kind of First Amendment analysis. But if the relevant question is, could you just bar people on the basis of a protected status from creating an account? And it's not going to affect your message. They want to, lurk on X and read other people's posts. I think that kind of law would certainly be valid. I want to briefly address.
So you should be allowed to listen, but not to be able to express yourself. All right. Okay. They need to ask why he did not use non-declaratory statement. What is his basis for his declarations in the text? Yeah. The what. The what is exactly it. The what is precisely it. No, your smarts are right, and anyone disagrees comes through me. Thank you. Thank you, Worcestershire. Anyone disagrees with me, you got Worcestershire to contend with. The people that argued a baker had to bake cake with content he objected to are now arguing a different entity can refuse to bake a cake because they were given Section 230 immunity. Very well said, Bill Potter. Very well said. Yeah, precisely.
Address, Justice Gorsuch, the question you asked about the scope of CDA preemption under Section 230. Just to be clear on this one, I want to say there are unresolved issues here. I would warn the court away from trying to resolve exactly how much conduct CDA 230 protects and exactly how that interacts with the Texas law here. The only point I would make is that there are questions about what it means to act in good faith, questions about what it means for the platform to take down content that is otherwise objectionable. But however those interpretive disputes might shake out in a particular case, surely Texas here isn't saying that its entire law is preempted and it has no effect whatsoever, and CDA 230 fully takes care of the problem. So I think what the court could do, not knowing exactly the scope of how that preemption issue might be resolved, is to say whatever exists in that category of speech that Texas is prohibiting, the editorial decisions it's countermanding on the one hand versus what CDA 230 would authorize on the other hand, whether that's a big category or a little category, all of the things in that category constitute protected decisions by the platform that haven't been adequately justified. And I think that's all you need to say about the preemption issue in this case.
If a legislative body enacts a law requiring viewpoint neutrality in some area, and it does so because it is concerned that people who express a particular viewpoint are suffering discrimination, is that law unconstitutional on the ground that the intent of the legislative body was to benefit a particular group?
He's so smart, Alito.
No, I don't think that kind of law would immediately be unconstitutional. And again, I think if it's structured like a generally applicable public accommodations law, there might be important or significant governmental interests in being able to protect against that kind of discrimination.
Unless there are any further questions?
Can I do one more?
Sure.
Government has spent a lot of time defending net neutrality, so maybe I should have asked you this with respect to Florida's law, just given the breadth of that law, and why are internet service providers, in your view, so different? And what if an internet service provider wanted to make certain content distinctions?
Internet service providers are fundamentally different because they are engaged in transmitting data in order to make websites accessible, and that is not inherently expressive. They're certainly providing the infrastructure, the cable, the fiber optics, and the service to make sure that you can log in on your home computer and access the internet writ large. But along the way, they're not compiling that speech into any kind of expressive compilation of their own. So we would put them in the same category as telephone and telegraph companies or UPS, where you could say, sure, they're literally facilitating the transmission of speech, but they're not creating an expressive product that could implicate the First Amendment principles at stake. Now, then you might ask, okay, well, what if they want to start discriminating with respect to the service they're providing for particular types of websites?
This woman is smart. You can't say otherwise. She's smart. She's breaking down these arguments very effectively. And she's distinguishing between an internet service provider like Verizon and a big tech like Facebook.
The kind of quintessential example of this is an internet service provider that decides to slow down service to a streaming site, let's say Netflix, because it wants to direct internet traffic to some other website of its own choosing, maybe its own streaming service. We think net neutrality could come in there and say you're not allowed to discriminate based on content in that way. But that's because, again, there would be no expressive speech or compilation that you could attribute to the internet service provider itself. People don't sign up with Comcast or Verizon to give them some kind of limited, curated access to the internet. They're engaging in service with those companies because they need someone physically to transmit the data so they can get access to the whole internet.
Can I ask one? I don't have to buy anything you just said to rule for your position in this case, or anything you just said on net neutrality, right?
You do not have to agree with me, Justice Kavanaugh. I hope someday, if it comes to it, to persuade you.
I'm not saying, but I just want to make sure that's walled off.
Nothing about the court's decision in this case would at all affect the net neutrality issue. You know, we think that here the platforms are engaging in expressive activity that's protected by the First Amendment, and you can leave for another day all of the kind of conduit questions that come up in the net neutrality context.
Thank you.
Thank you, counsel. Mr. Nielsen?
Thank you. It's been a long day. Mr. Chief Justice, and may it please the court, this is not the first time that new technology has been used to stifle speech. Telegraphs also discriminated based on viewpoint, prompting a national scandal. Yet under the platform's theory, Western Union was just making editorial choices not to transmit pro-union views. Today, millions of Americans don't visit friends or family or even go to work online, in person. Everybody is online, the modern public square. Yet if platforms that passively host the speech of billions of people are themselves the speakers and can discriminate, there will be no public square to speak of. We know this because Twitter has admitted that their theory of the First Amendment would allow them to discriminate not just based on what is said on the platform, but, quote, on the basis of religion or gender or physical disability. That's not the First Amendment. That's Lochner 2.0. And as more than 40 states warned the court, the implications are gravely serious. For example, as New York explains, if these algorithms are constitutionally protected, platforms may be able to continue selling advertisers the ability to discriminate based on race.
Yep. Yeah. See, and Paul Clement, who was the first one who argued on behalf of big tech, you know, he's basically like, well, don't worry them. They're all good folks. Facebook, they're all good folks. YouTube, they're all good folks. But what if they're not? What if they're not? You can't have a legal argument that's based on the fact that these particular actors who you're standing on behalf of, that you believe they happen to be good people, because you have to pass a law that's going to apply to all Americans, whether they're good people or bad people. So even those people who think that these are the good people, which I disagree, I don't think they're good people. I think they're terrible, 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 terrible people. Still, you can't pass a law in the expectation that, well, because the ones we're addressing right now are the good people, that we should just let them do what they're going to do. It's ridiculous. It's not a legal theory.
Or, as Professor Lawrence Lessig, Zephyr Teachout, and Tim Wu, who do not typically file briefs in support of Texas, caution not just states, but Congress may be powerless to address the social media crisis devastating the lives of kids. HB 20 is a modest effort to regulate such power in the context of viewpoint discrimination. Platforms can say anything they want under HB 20 about anything. There's no limit. They can say anything they want. Users can block anything they don't want. There's no limit on that. All that's left is voluntary communications between people who want to speak and people who want to listen. This law is thus nowhere near the heartland of the First Amendment. Instead, this is democracy and federalism, not a facial pre-enforcement injunction. I welcome the court's questions.
All right, so this guy sounds like, as far as his litigation skills, I think you all can tell he sounds weaker than Paul Clement, or well, I won't say weaker, certainly less experienced than the first two, but his arguments are sound so far. Hopefully he holds up to scrutiny by the court.
If this was so clearly within a common law tradition, as you suggest, why hasn't Congress seen fit to act as Texas has? And it appears that Mr. Clement suggests that actually Congress has acted in the opposite direction. Would you comment on that?
I think this is a softball that Thomas is giving him. All right. So if you're right, why hasn't Congress stepped up? Well, because Congress sucks. That's the real answer. Hopefully he has a better answer than that.
Yeah, I don't see how, with all respect to my friend, how their reading of 230 is at all consistent with what Congress said. They have all sorts of kind of policy arguments about how 230 ought to work, but if you actually just read the words of the statute, it doesn't work. So his suggestion that Congress somehow has kicked out Texas or said that that's not how he wants it to be, I don't think is consistent with the text of the statute. I didn't hear a lot of textual argument coming from Mr. Clement there. So that'd be.
I like him coming into textual arguments. That's a strong way of appealing to Thomas and being like, read the text. Because text says they have to act in good faith. If we look at 230, section 230, any action voluntarily taken in good faith. If it's in good faith, it's otherwise objectionable. So it's not to give them carte blanche. It's to say you have to be acting in good faith. It's been interpreted to be an assumption that they're always that somehow they're never acting in bad faith. Never acting in bad faith, despite all the indications to the contrary. But he's correct. It's a great point by Nielsen. Better argument than what I was giving him of Congress sucks. Much better argument. My argument happens to be more true, perhaps, but it's pretty strong. A pretty strong counter argument.
My first line answer. My second line answer is I have no idea why Congress does or does not do, but I do know.
Oh, that is a Congress sucks answer. That's what he's coming to. Well, Congress kind of sucks, so I can't tell you why Congress does or doesn't do whatever the heck they do. They suck. We all know they suck. There you go. Good. I'm liking Nielsen.
That Texas has the ability to protect Texans, and that's what Texas has done here.
Love it. I love it. Read those two lines. That's my first line answer. My first line answer is he's reading it wrong. Second line answer is Congress sucks. So Texas had to do what Texas is going to do because Congress sucks. So there you go.
Counsel, you began by saying, the platforms, they want to keep out this person and that person on the basis of race or sex. And then you said, that's not the First Amendment. Well, the First Amendment doesn't apply to them. The First Amendment restricts what the government can do. And what the government's doing here is saying, you must do this. You must carry these people. You've got to explain if you don't. That's not the First Amendment.
Well, respectfully, Your Honor, the First Amendment is big. It applies in a lot of different ways. So it's true for us, like we're saying, because this isn't speech, it's conduct, we can require viewpoint neutrality. But in other cases, the same companies are saying when New York or some other state says, hey, you can't have algorithms that try to hook kids, they say, well, we have a First Amendment right to do that. It's the same First Amendment that says, if it's all First Amendment, then I guess it's going to be hard for Texas to say you have to be viewpoint neutral, but it's also going to be hard for California and Illinois or anybody else to say you can't have an algorithm that hooks kids because it's all the same.
I'm sure it's the same for all the other states. The question is, they don't have the obligation to act in the same way that you as the state has the obligation to do. They can discriminate against particular groups that they don't like, whether it's a group that encourages kids to take the Tide Pod contest or something else, and you have different obligations.
I guess a couple ways I could respond to that, Your Honor. The easiest one I'm going to talk about is, if I may, common carriage. My reaction coming to this case was the same as yours. My reaction was, well, wait a minute. It's their own platform. You can't censor, like they're private. But that's the exact same scenario that came up with the Telegraph. The idea that Telegraph was dumb pipes is not true. Instead, what the Telegraph was, is they had the technological ability to say that we're not going to let this type of speech through.
No, you're absolutely right, but it's kind of begging the question. You're assuming that they're like the Telegraph. It seems to me that that's a big part of what the case concerns. And I'm just not sure that, the Telegraph had particular compelling type of monopoly. If you didn't want to use the telegraph that was there, you usually didn't have an alternative choice, whether you're talking about railroads or other types of common carriers. I'm not sure the same thing applies with respect to social platforms.
So I give you my theory for why common carriage is important here.
Do it. Lay it out, Nielsen. Give us the common carriage. Please do well. Please do well. Please do well.
As I look at the cases, and I agree, they're really hard to figure out where conduct starts and speech ends and all of that. And you look at all of the various cases this court has said, some commentators say they can't be reconciled. I'm not sure about that. But I think it's a helpful way to think about it is we know that there is a line between speech and conduct. And we know that common carriage has always been on the non-speech side of the line, the conduct side of the line. So if this falls within the common law tradition of what is common carriage, nobody's ever thought that falls on the speech side of the line. So we can't make them, say something otherwise that they didn't want to say. The whole point of it is that's a signal to the court. That's a way that the court can figure out which side of the line are we on.
Well, it turns on whether you're saying who do you want to leave the judgment about who can speak or who can't speak on these platforms. And do you want to leave it with the government, with the state, or do you want to leave it with the platforms, the different various platforms?
Well,
the First Amendment has a thumb on the scale when that question is asked.
It does, and that's why it's important, I said, to go back to look at the history on this, because at some point the First Amendment has to end, or everything is covered by the First Amendment. This court has said that the way that we tell the difference is whether it's inherently expressive. And the court has said what they mean by inherently expressive. They talked about in Miami Herald, you're not a passive conduit. We talked about in Hurley whether you're intimately connected. Well, this court last year had a case in Tamna where they talked about what these platforms do, and they say that they are passively connected to the speech on their platforms, and that they're agnostic about the content. It's just one big algorithm that's matching things together. And I think that's important. But I also want to stress, if I may, again, this is a facial posture. And if you look at the breadth of our statute, there's the talk about, whether you have to host somebody's speech. There's also about you just want to read Facebook. That is one of the provisions of our statute. You go online in the morning and you want to see what's going on in the world. According to their theory, they can stop you from doing that too. And that's surely public accommodation law. The idea that they don't like somebody because of their race or their disability or something like that, and we're going to say we're not going to allow you onto our platform, that surely cannot be constitutional.
That's where really I think he's more powerful with this argument. Imagine Facebook decided that they just said, you know what, no more Asians on our platform. We're done with the Asians. If you're Asian and we suspect you're Asian, you're not on our platforms. Everyone's going to say, well, they're a private company. They can do that. Can they come in here and say no more homosexuals? No more, nothing promoting homosexuality can be on our platform. Could they do that? Do you think that people would be like, oh, that's okay. They have a right. They're a private company. They can do that. Who would actually believe that they get away with that?
That's what I mean by that's Lochner. That's you've gone beyond any content of the platforms themselves on their page to saying we're not going to let people even look at what we're selling. That's a bookstore saying we won't sell you our book. That's different from saying we won't publish your book.
Do you think that there are any unconstitutional applications of your law?
Let me get to this. Sorry. Why does Texas law have to fit under 230? 10th Amendment gives all rights not given to the fed, state, and people. Texas law is only interstate. You mean intrastate? Well, I guess because it would supersede Texan law. If it's congressional law, it's federal law, it would supersede them. And if it's not in concert with 230, in that case, in theory. But they're not really raising 230. They're simply saying 230 implies to us that they should have the freedom to do this and that it's part of it's part of the big tech's free speech to control their own algorithms. So it's not that Texas has to fit under 230. It's that 230 is helping us come to a conclusion that their algorithms and how they moderate their content is part of their free speech. I think that's how Paul Clement would answer that. Not that I agree with Paul Clement, but on this particular issue.
I mean, that's a hard question. I suspect that there might be.
What would they look like?
So the one that comes to mind would be, imagine, and this comes up in their brief, they pick like the most vile example, and they say, imagine a publisher didn't want to publish the book written by the Proud Boys, was the example that they use. I think you might very well have an as applied challenge.
Proud Boys are like the most overused and improperly example of racism, which supposedly they're not. I mean, I asked Ron Coleman this. I was like, I don't follow what the Proud Boys stand for. I don't know anything about the Proud Boys. But I actually asked him when I was on the phone with him once when I was in Washington, and I met a guy who's representing Ricky Olivares. And I was like, Ron, I don't know anything about the Proud Boys. Do you? Are they racist? He started laughing. He's like, no, not at all. They're a joke. But that's all I know about the Proud Boys. But somehow they're the new KKK.
To that. But the problem for them is they pick the most vile example when I think all of it would say, well, wait a minute, surely you can let them on Facebook and you can't kick them off because their grandma said something outrageous, right? So there's got to be a limit there. And that's why a facial resolution of this case doesn't work. And if it is,
and how do you separate the one from the other? Where's the line?
That's hard, right?
That's not a good answer. You don't start your answer with "that's hard," right? That's not. You don't say that's hard. You just jump right in. See, this is his nervousness, which is making him come across rather weakly, unfortunately. I have concerns about how this case is going to go. And you're right, Allegan. Everything is interstate these days. It's true. It's sad.
I would say this court struggled with that in 303 Creative because it's really hard to know when something becomes inherently expressive. And the court's cases like Dale about when does something that happen, all of those are hard cases. But in all of them, this court has had facts. They've actually looked at the facts of the case and tried to figure out as applied whether that makes sense here. In this situation, there's a million applications of this law that are perfectly fine. And they pick some of the most vile possible hypothetical.
That's a weak argument. It's a weak argument. I don't like this. He's ceding too much ground. When you say in some ways it's unconstitutional, you're opening up for SCOTUS to say, yeah, we think it's too broad because then its breadth makes it in certain ways unconstitutional, so we're going to strike it down. I don't like the way he's going here. I don't like this. I don't like this. Come on. Come on, Aaron. Come on, Aaron. Come on, Aaron. I would have said no. There's no context where it's unconstitutional.
Ignoring, by the way, the provision of Texas law, which they never address, which says under Texas law, if you don't want to hear content, they're allowed to make sure you never hear that content. So all you have left, I mean, again, they never mention at all. That's like focus point of our brief. They never respond to it. But that means all that's left is, I don't want to hear this type of speech. I just want to hear this type of speech. And it's just voluntary communication. That's a telephone.
Mr. Nielsen, you heard during the prior argument a lot of conversation about how broad Florida's law was. I read Texas's law to be more narrow in its coverage, that it wouldn't sweep in some of the examples we were using in the last argument, like Uber, Etsy. Am I correct?
I think that's fair, Your Honor.
So what platforms does Texas's law cover? Am I right that it covers only the classic social media platforms like YouTube, Facebook?
So that's what their deponent has said.
So Barrett sounds like she's on the right side of this issue, hopefully.
The only one that they were sure that it was covered is Facebook, Twitter, and YouTube.
But that's their deponent. Presumably Texas is the one who can if it was in the Texas courts, I mean, it's not them. They're not the ones that get to decide authoritatively what the scope of the law is.
Well, correct. I mean, we would have to prove it at trial that they're
what's
subject
Texas's
to it.
position about the scope of the law?
Well, the law says.
And that's a fair point you're making, Debbie. That's a fair point. If I didn't get to hear the first argument yet, it was 2 hours and 20 minutes, and I haven't had a moment to do that as of yet. So if you tell me that was commonly something that commonly came up in the prior argument, which ran for 2 hours and 20 minutes, and with respect to arguing the Florida law, that in this context would make it less egregious of an error. You're correct. Okay, thank you. I appreciate that. That makes me feel a little bit more enthused. Dormant clause kill the republic. I'm not sure what that means.
That it applies to any platform with more than 50 million active users per month.
Oh, dormant.
So I'm not sure where some of the other platforms fall on that. The ones, like I said, that we know are the three biggest ones fall.
So you're making that judgment based on size. So it's nothing about the definition. I mean, in the last argument, we were pointing out that the Florida law in defining what a platform does and how it works would encompass Uber, for example. But you're saying that you're just distinguishing this based on numbers.
No, I apologize, Your Honor. There's also a separate provision which defines social media platform as a website open to the public, allowing a user to create an account, and enables users to communicate with other users for the primary purpose of posting information, comments, and so on.
And so is it Texas's position that that definition then covers the classic social media sites? And by classic social media sites, I mean sites like Facebook and YouTube.
Yes, Your Honor.
Okay, and that it would not sweep more broadly to some of these other things like Etsy?
I don't think so, Your Honor. But
the district court thought it covered WhatsApp. Do you think that it doesn't?
I don't know. I mean,
WhatsApp sounds like it's part of. It's more social media. It is closer to social media.
I don't know the answer. That's the best I can give you. I don't know. We don't have discovery into that. We had the deponent. Their own witness said these are the three that we are sure are covered. It might very well be. That's another reason why it's.
That's a social media company which is designed specifically to facilitate communication between various private individuals. That's much more classic social media than a buying app, or or Amazon, or some other thing where the primary focus is not to have people engaging in exchange of ideas, but it's an exchange of goods and services.
Hard to do this on a facial basis because it might very well be WhatsApp, which sure looks like a telephone to me, would be covered by.
But what about, I mean, it's within the big three, there are some email looking functions, aren't there? I mean, I appreciate that it's hard to do this because we don't have a record, but I understood that Facebook, for example, which you say would be covered, has a messenger function.
Yes, Your Honor.
Which looks like email. So wouldn't we have to do this at the level of the functionality of these various platforms rather than at the kind of entity level?
Yes, Your Honor, you would. And it's not just that. You'd also have to go through the different types of verbs included in our statute for censoring, including the one that they keep ignoring, which is the ability to receive the expression of somebody else. That's when I say you look at the text of the statute. Their theory would mean that even if you just want to lurk and just listen and see what other people are saying, they can kick you off for any reason at all. So if you have somebody who had never posted anything, or their speech is identical to the speech of somebody else, their theory is, well, we can kick you off. That seems to me pretty far into the world of public accommodations. Like, 303 was a narrow case. If that's what 303 means, like, boy, now we're really, really, really big. Hence Digital Lochner or Lochner 2.0, the idea that everything can't be protected by the First Amendment. At some point, there's lines of content.
Counsel, during the prior argument, which I'm sure you listened to attentively.
Yes, Your Honor.
There was some discussion about how difficult life will be if these injunctions are dissolved, and a parade of horribles and expenses and difficulty geofencing Texas or Florida. Can you address some of those concerns?
Yes, two answers, if I may. First, there is some suggestion that the prohibition on discrimination against Texas or a part of Texas is somehow a trap to keep companies in. That's not true. You read the statute, that's not what it says. There's a separate provision in the statute, which is the jurisdictional hook, which is, if you're doing business in Texas. And by the way, even if Texas tried to do that, there's something called personal jurisdiction that you can simply just leave a forum. That's this court's decision in Ford. So that argument, it's just not true. But the other part I think is really important about this is Texas's law. What is the remedy here? It's an injunction. There's no damages here. It's an injunction. And in fact, we know that it's not going to flood the courts because the injunction against the Attorney General is limited to the Attorney General. There's private enforcement of Section 7, and we have a handful of cases because you don't get damages. So it's hard unless you have a really darn good case to be able to go to court if nobody's going to get damages for prevailing, which I think matters a lot in terms of like what are the real world consequences here. They're going to have some lawsuits by the Attorney General for injunctions. And if we can't prove it, if we can't prove viewpoint discrimination, they will prevail.
Did you say they could?
That's a good argument for him. That he's like, so if you don't, if SCOTUS knocks down the injunction, what danger are these companies subject to? What terrible things going to happen to them that maybe will win in court and get an injunction to stop them from doing what they're doing? Maybe. But it's not like they're going to hit with penalties if they fail to comply with the law. It's just that maybe we will have the power to stop them from doing it if we can prove it. But it's not like they're facing like there's any sort of financial, that they're breaking a law. There's no criminality behind it. It's just that we have the power to stop them if we see that they're continuing to engage in viewpoint discrimination. What's the harm? Great. It's great. It's a very strong argument.
Stop doing business in Texas under this law?
Yes, Your Honor. Of course. I mean, it's true under the law, but it's also just true as a matter of personal jurisdiction. Anybody can get out of any jurisdiction.
I just meant under the law.
Correct. Yes, under the law. Yes, Your Honor.
How does that work? If you're talking about Facebook, I mean, if somebody were emailed and all that, if they send something into Texas, are they doing business in Texas?
No, Your Honor, though that would be a fun personal jurisdiction case. The answer, as I understand it, is you have to purposely avail yourself of the forum. So merely because somebody can look at your website, if you're not having some purposeful direction towards the forum, that's generally not sufficient.
No, it's a worldwide sort of thing, and people are going to be sending stuff left and right, and you know that as the company. I'm not sure. I don't see how they can wall off Texas from the activities of the social media platform.
Well, I mean, two answers. One, they have the technological ability. It's called geofencing, which they can carve off. I mean, if they wanted to, they could probably carve off this building itself. They have the ability all the way down to that granular level. But again, more than that, it isn't just it shows up there. If you want to have
Roberts is such a boomer. He's like, can they really just wall off Texas? Yeah, they could. I'm just saying there's no Facebook there. They have that ability.
Count with Facebook or Twitter or any of the others, like there's a contractual relationship between the two. So they have customers that are in these places. And people say, well, they don't have any customers because they're not charging any money. Well, we know that if they're not charging any money, like you're the product. So they're taking your data and they're selling it to the advertisers, which is why it's so important that we recognize that if this algorithm is protected by the Constitution, then they can take that data and sell it to people and have highly targeted ads based on socioeconomic characteristics. The New York brief explains that on page 12, which I think is important and shouldn't get lost in this. They pick, again, the most vile examples, which are the fanciful things that we don't usually do in a facial posture. And they try to say, well, that means the whole law should fail. There's a whole lot of perfectly fine applications that the court needs to remember and not lose sight of.
What about terrorist speech? How's that handled?
Yeah, so a few ways. First response that I would have to that is the provision of the statute that they ignore, which is no user has to receive anything they don't want.
No, but the criminality, they exclude criminality. That's how. And terrorist criminality.
Right, that still allows the communication of it, so that's
all right. So let's go through that there. But now we're most of the universe is gone. But the next level of this, under Texas law, if it's illegal, they don't have to do that either. So I'm assuming that a lot of the terrorism is going to be, like we're inciting you to come join Hamas or something like that.
No. Just the pro-Al-Qaeda kind of messages that were common pre 9/11, post 9/11, not necessarily incitement, but advocating.
Okay, sure. All right, so we put aside the first two levels here. Third, they're allowed under the statute to pick any categories they want. So if they want to keep that category for which the speech falls in, that's their choice. If they want to cut that category out, they're free to do so. They just can't do so on a viewpoint basis. And at the end of the day,
So when that last clause, they can't do it on a viewpoint basis. How does that work with terrorist speech?
sure. So it's hard to say with terrorist speech because you'd have to pick the category, but assume that it is,
Al-Qaeda.
Al-Qaeda. You can't very well say you can have the, anti-Al-Qaeda but not the pro-Al-Qaeda. If you just want to say no one's talking about Al-Qaeda here, they can turn that off. And at the last point, this is at the very end of the game. So you've gone through all of those things. All you have left are voluntary people wanting to talk to each other. And I mean, people say horrible things on the telephone. And I don't think we've ever thought, well, you know what, we're going to turn that off because we don't want the telephones providers to be able to say, have that sort of right to censor. If I may, I mean, with some hesitance, I want to talk about Orwell a little bit. And I say that with some hesitance. But my reaction coming to this case was very similar to yours. I looked at this and I'm like, wait a minute, these are companies, they have their own rights. We don't generally think of censorship as something from private people, that's the government. Here's how I came around on this. Maybe it'll persuade you, maybe it won't. I came around on this to say this is something further up the food chain than that ordinary level of political discourse. This is just the type of infrastructure necessary to have any kind of discourse at all. That's why I keep going back to the telegraph. This isn't, the level of discourse where they're making the content decisions that we make our decisions based on. This is the infrastructure that we need to have any sort of discourse at all. So if we say we want to have that type of infrastructure, not have, censorship on it, that would mean we would have to have a massively increased federal government because it would have to control all the infrastructure. And then we would have, okay, now you can't discriminate based on this kind of infrastructure of how things work. That's not, that is Orwell, right? So for me, the answer is for these kind of things like telephones or telegraphs or voluntary communications on the next big telephone telegraph machine, those kind of private communications have to be able to exist somewhere. The expression like, sir, this is a Wendy's. There has to be some sort of way where we can allow people to communicate.
And is that just because of the modern public square? I mean, Mr. Clement has said many, many, many times that there's a distinction between public and private, and that's sort of driving his analysis as to when and under what circumstances this kind of regulation can be done. And are you just rejecting that because you're suggesting that they merge in this situation given the nature of the communications?
I'm not doing that. And that's, again, I'll try again to be artful. These are complicated concepts, but I think about the common carrier as a really useful tool for this court because we know that there's hard lines to draw. It's really hard to tell the difference between FAIR and Miami Herald, like in the application, especially when you kind of get down to the granular level. It's really kind of hard to tell. I think it would be helpful if the court had a compass that could kind of like give it some direction of where to draw those lines.
Good.
And common law, common carriage is that compass.
But are you suggesting that a common carrier, as the SG pointed out, could never have First Amendment protected activity? I mean, that's why I keep going back to, doesn't this have to be not at the level of entity, but at the level of sort of what exactly are they doing in a particular circumstance? Because you just seem to say, well, these are common carriers, so everything they do is conduct, and therefore we can regulate it. And I don't know that that's the way we've ever thought about this.
Well, it is how the court thought about it with telegraphs, which I think is a useful way of thinking about it. I mean, my friend in the government says, well, they're just transmitting speech, but that's totally question begging because they have the technological ability not just to do that. The reason that cell phones don't screen your calls or telegraphs didn't
Well, Mr. Nielsen, I'm sorry to interrupt, but I think you'd agree with Justice Jackson, though, that there might be some speech that these carriers, even as a common carrier, would be their own.
Yeah, 100%. Yes,
and you do have to take that function by function.
Yes, and that's the other part of this law, which I think is so important, is to recognize is we don't say one word about what they can say. So I would kind of disaggregate the functions of what's going on here. They have,
in other words, if they actually, if if they have a message that they want to come, YouTube wants to issue a statement, so that's different from how they're controlling their algorithms, and they can say whatever they want in that context. That's totally fine. That's them using the common carrier. That's not them providing the services of a common carrier.
The one function, which is they are creating a message, we do nothing about that. They can say whatever they want about specific posts or anything, and that's fine. But there's a separate thing that they do, which is facilitate conversations between two people, which is like a phone.
I understand that. Now, one of the things that we've sometimes looked at in the past, this court, in the common carrier world, is market power.
See, give Gorsuch what he wants. He wants to say, yeah, it is because of their size. See, don't be afraid of saying that these guys are giants. Call them out for what they are. They're freaking giants. You can say start your own YouTube. When you say that, people laugh at you. No offense to you fine people in the Rumble ghetto, but it's like people laugh at you. Start your own freaking YouTube. It's like, what the hell does that even mean? You know that you're not talking to the same number of people at a certain point in time. When you become a certain size that you're servicing, I don't know, maybe the size is 1 billion people. Maybe that is a nice round number. And when you're serving 1 billion people every day, when you start measuring your market share based on what percentage of humanity you are serving, that at that point, maybe there's nothing wrong with saying that we should start looking at you as a common carriage. Maybe it's not a crazy thing. It's not a crazy thing at all. Especially when the service you're providing relates to free speech, to enabling free speech. And that's the primary focus of what you're selling yourself as. So we're trying to figure out if you're a common carrier, and the service you're providing is a basic fundamental right, like the ability to be transported, go from one place to another, the ability to speak your mind. And that's the service that you're providing. And that you're measuring yourself based on what percentage of humans are not using your service, that perhaps you enter into a different stratosphere. And that's not too much of an onus to put on them, considering their size, but considering the mass of the company. That's what Gorsuch is setting him up to say. I hope he grabs this. He's throwing him a lifeline. Grab it, Aaron. You got this.
Yes, Your Honor.
And how do you analyze that here? On the one hand, there are network effects that one would take account of in any analysis of market power, and that might help you. On the other hand, this is a bit unlike a telegraph in the sense that there might only be one right of way to run the wires. It might be serious practical barriers for more than one set of wires.
Another way we're not like the telegraph is that they're basically, I don't know, something like 400,000% bigger than the telegraph ever was. That's another way. Yeah. So it's true. That's perhaps there was a monopoly element that was inherent by dint of practical physicality. You're not going to have every telegraph company having their own telegraph wires. Just because you don't have the property, you're not going to eat up that much property. It just seems like it's not a benefit to society to have competing telegraph companies each set up their own wires. But at a certain point in time, you sort of have to say, I think market share has to be, the market share here is so dominant that it's got to come into the calculus.
Here, one can start a new platform, at least in theory, anytime.
Yep. So I guess
fewer barriers to.
Yeah, I don't have a problem with that either. Although I don't really necessarily trust the government because they could designate me as being part of a terror group tomorrow. So, is Google about to be broken up via antitrust? They delayed by making Alphabet and pretending they're separate companies. I don't know. I'm not predicting that one.
Entry, but market effects.
Sure. So the first answer is if we are not talking about speech, if we're just in the world of conduct, then we're not talking about market power at all. And we know that because cell phones are intensely competitive markets, and yet they're still all common carriers. But let's move that aside. Now we're saying there's some sort of reason to focus on market power. It's true. This is not like the market power of there's just one bridge. But as an economic matter, there's really no difference. And I know this, here's a simple kind of a way to look at it. Twitter has its platform. There's a lot of competitors for Twitter, would-be competitors, including Threads from Meta, which is backed by like one of the largest companies in the world. They invested massive amounts of money to try to break up the Twitter monopoly, and they failed miserably.
What do we do about, I mean, there's some legislative findings here about market power. What deference do we owe those, if any?
I would think considerable deference, Your Honor. This is a sovereign state. We don't usually treat states like the FTC, where we subject it to, arbitrary and capricious hard look review. The state is entitled to make determinations as a matter of law as to how things are. And obviously, at some point, it might be so far afield, but I sure hope that the states get, some deference on such important questions from this court.
Mr. Nelson, can I just? Oh, sorry, go ahead, Chief.
This may be the same question that Justice Gorsuch was asking, but does the nature of the economy at issue matter to us? I mean, the social media platforms, the internet, all of that stuff, an incredibly dynamic market. The government, maybe not so much. And yet it's sort of a inflection point to say that the government has the authority by categorizing the members, the participants in this dynamic market as common carriers to take over extensive regulation of them, not with respect to communication, but all sorts of things. I mean, when you're talking about railroads,
he's going to come out on the wrong side here. He's going to come on the wrong side. He's basically saying, well, for all you know, YouTube will be 3% of the size tomorrow. Next month, YouTube will be 3% of the size of what they are today because it's dynamic. So if you're going to root in on market share, and maybe that's why he avoided saying market share, but come on, you have to deal with reality. So at that point, maybe they wouldn't be subject to it anymore. Perhaps they stop losing that subjectivity once if they shrink in size. That's an answer for Chief Justice. Okay. Only while they're measuring in how many hundreds of millions, only at that point do we actually look at them as common carriers. I don't know. Maybe when they have more customers than there are, Americans, that America can look at them as being common carriers. That's one way of looking at it.
Telegraphs. It's not just moving transportation. It's what the railroads look like, what the safety things they have to have, a whole range of things that, in the Wild West economy surrounding the social media platforms and the internet may be totally inapt. Now, I don't know if it comes at a time when you need to make that transition or not, but that is a very big step when it comes to the extent of government regulation.
I certainly think that's fair. My response is going to be, this is a facial pre-enforcement injunction. We should at least be able to make our showing on the facts. We're quite confident that we'll be able to show not just market power, but durable, extensive market power here. I actually don't think it would be even all that difficult to make that showing. So to the extent that market power is a requirement, I think that they haven't shown that they're likely to prevail on the merits as to that. Which is another reason why a facial injunction is just simply inappropriate. Bring in an as-applied case, and we're happy to litigate that. It's really hard what's facially, they can pick a few examples and then say the whole thing fails.
Mr. Nielsen, what besides market power, I want to give you a chance to elaborate on your definition of common carrier. I mean, you've said conduct, market power, what else?
Sure, so the main requirement of common carrier, this is where common carriage and public accommodation are, if not cousins, maybe twins, is it has to be open to the public, which means that it's not a private associational group or something like that. You hold yourself out open to the public with non-differentiated contracts. This is a contract with everybody. So that's the very first one. The second is it has to be the type of industry that has traditionally been regulated as such. So for public accommodation, that's your inns and your restaurants. For common carriage, that's where you're talking about things like bridges and telecommunications.
But then you get into the problem of having to draw the analogy, right? I mean, the chief just called the internet kind of like the wild west of the internet, and the internet looks a lot different. Even each of these platforms has different functionalities within it. So, when you extend comment, when you call,
just if their service is to provide basic fundamental rights. So fundamental rights, freedom of expression, fundamental rights, freedom of travel. Right? I mean, that's what their services are.
Grist mills and then railroads and cable companies. Each time you encounter something new that might qualify as a common carrier, you have to make a decision. Does it fit the bill or not?
Sure. So I guess I can keep going further. That's why some courts have said, well, maybe there's additional requirements that we put on common carriage. One is market power, which is not everybody says it. I don't know how that works with cell phones, but they've said, well, you need market power. And the other was it has to be somewhat invested with a public interest. And here, under that, we know that if it's state action to block somebody from your Twitter account, how can that not be infected with a public interest?
Thank you.
Justice Thomas? Justice Alito? Justice Sotomayor?
I have a problem with laws like this that are so broad that they stifle speech just.
Wrong side of every issue, Sotomayor. Literally the wrong side of every single friggin' issue, Sotomayor. Gosh, she's so annoying. Oh my gosh. Oh, Lord. Here we go. Wrong side of every friggin' issue. I have a problem with laws like this that are so broad they stifle speech. Stifle speech. This is a law. Let's understand what she's calling stifling speech. A law that says no stifling based on viewpoints is a law that I have a problem with as stifling speech. Jesus effing really. Sotomayor. God, it's a law that says don't stifle people based on their viewpoints. And she starts off with, I have a problem with laws like this that are so broad that they stifle speech just on their face. No, on its face, it doesn't. You have to get into a whole convoluted type of pretzel where you basically say to yourself, oh, because it's speech of with their algorithms and their conduct over here is a nature of speech, and that's what's being stifled, as opposed to, oh, I don't know, but it says facially, which is don't stifle people based on their viewpoints. How can you be so wrong all the time on everything, Sotomayor? How can it's like your brain is like up is down, down is up, and it's like men or women, left is right. God only knows. You're living, cats and dogs are living together. I don't even know what the hell is happening in her world. What is happening in your world? Who infected your brain? I don't understand anything that comes out of Sotomayor's mouth. Nothing. I don't understand this woman. I don't understand anything about this. I don't. How does someone? This is like the most aggravating appointment, perhaps in the history of the Supreme Court. I mean, stifling free speech. This is what your first thoughts are when you come out and talk to this gentleman over here. I have a problem with laws like this that are so broad they stifle speech just on their face. No, on its face, it doesn't. You want to tell me that you have some sort of cockamamie way of looking at it, that you say that this is stifling speech. All right, maybe it is. Maybe you have a problem with it. We all know the only reason you have a problem with it is because it's basically affecting your little Kindler there, your little child, who it's like, oh yeah, you're standing up and clamping down on conservative viewpoints. Trust me, if big tech was stamping on the left, she would have no problem with this, and she wouldn't think that this is stifling free speech on its face. But cockamamie Sotomayor has to be like, this is what the law on its face. God, oh man, Sotomayor. Wrong on everything, every single time, like a clock She's like an atomic clock of wrongness. Is Sotomayor? You're an atomic clock of wrongness. It's humiliating. It's humiliating that this is justice in the mind of Sotomayor. God, oh man,
it's on their face. Meaning, I think that's what the government's been trying to say. If you have a particular type of speech that you want to protect against or promote, it would be one thing to have that kind of law. But we have a company here, Discourse, who's also a direct messaging app. And there's no question that your law covers them. But they tell us that their whole business model is to promote themselves to a particular message and groups of messages. So they're not doing it indiscriminately. You're basically saying to them, if they're out there and they're a common carrier, they can't have this kind of business model.
I mean, two responses, if I may, Your Honor.
First response is, you're a jackass. That's what it should be. Secondly,
the first is, as to the particular company, we're only talking about the three largest, maybe more, depending on who falls within the 50 million, the largest telecommunications companies on earth. We're not talking everybody else.
Okay.
So, but as to the second point,
you're agreeing with them that basically this law is aimed towards them.
Yes, to the largest. We've never disputed that.
I only said that 14 times. I'm not even sure if it applies to WhatsApp. WhatsApp is pretty big. I'm not even sure if it applies to WhatsApp. I have to look in and check in with you as to whether or not. I basically only know that it applies to these three. You were basically asleep for 2/3 of the conversation here.
But even if you agree with all of that, I disagree with you, but I understand that there's still applications of this law that should be allowed to go into effect. I don't see how they can say that they can kick somebody off for off-platform speech of their grandmother. That can't be, or because they don't like it where you live in Texas. You live in El Paso and not Dallas, so you're not as valuable to the advertisers, so we're going to kick you off. Surely that can't be okay.
Justice Kagan? Justice
Two
Kavanaugh?
very quick ones on the deference to the legislative findings point. My memory is that there was a trial in Turner Broadcasting.
Yes, Your Honor. That's Turner too.
Yeah.
That's maybe there'll be a Paxton too. I'm not sure how.
Right, but there wasn't just Congress said this. That's good to go. There was a trial about that, right?
Sure, Your Honor. Yeah. And like I said, we're happy to go to trial. But
that's all I wanted to ask there. And then on common carrier, if a company says we're not a common carrier, we don't want to be a common carrier. We're carrying a lot, but we're not a common carrier. Can the state make them into a common carrier?
The state, that's a great question. And that was the first question I had when I came to this case. The answer is no. If you are not a common carrier, you can't suddenly become a common carrier. That's why I think it's important to think of it as a compass to kind of tell you where the line is. But I would urge the court, if you're interested, again, we've heard, read Professor Volok's article. One thing that really struck me as strange was, well, wait a minute, they have terms of service. So how can they be a common carrier? Because if you have terms of service saying you can't do this. And this court addressed that very problem. The case that he cited is New York Central v. Lockwood from 1873, where the court said you can't just get out of the duties of common carriage by contract. If you're a common carrier, you're a common carrier unless you stop opening yourself up to the public.
Seems a little circular, but I'll end there. Yeah.
Sure.
I just want to get a clarification. So you said that Facebook could geofence and just pull out of Texas? Was that correct?
Of course, Your Honor.
Okay,
yeah.
Because I was just confused. Mr. Clement was pointing out, that according to the provisions of the law, you couldn't, and I'm looking at 143A.002.
Let's pull it open, because I have the law open here. 143A, no, that wasn't it. That wasn't it. Where are you? This is it. Control F. 143A. .002. Censorship prohibited. If I make this big so you can all see it. Censorship prohibited. The social media platform or interactive computer service may not censor a user or user expression or user ability to receive the expression of another person based on the viewpoint of the user or another person, the viewpoint representing the user's expression, another person's expression, or user's geographic location in the state or any part of this state. So maybe that's where she's going with this, but I think she's confused. So hopefully he'll clarify that for her. Where are you?
And it says, that you can't censor users' expression, ability to receive information, etc., based on a user's geographic location in this state or any part of the state. So you don't understand that to say, well, based on your location in Texas, we're not going to let you post content?
Your Honor, this is one of the prohibitions of the law that they can't. Let me say it a different way, if I may. There's a provision of the law, which is the jurisdictional hook, that says who is subject to this law at all. If you choose to do business in Texas, then this provision kicks in.
Once you choose to do business in Texas, you can't say we're only doing business in Dallas, but not in Austin. But you can say we're not doing business in Texas altogether. That's where he's going.
And you can't discriminate against people after you've chosen to do business in Texas based on the status that they're in Texas. But if you don't want to do business in Texas at all, that's a separate provision, and you can get out of Texas. This is the prohibition on what you can't do. If you choose to do business in Texas, you can't darn well discriminate against somebody because they're in El Paso.
And doing business in Texas is what? Just allowing Facebook users to sign up in Texas? Or is it, Facebook accepting ad money from Texas corporations?
Good question.
That question has not been resolved by any of the Texas courts, because none of them have been. But as I read it, it is you have to have, customers in Texas. You've entered into contractual relationships with Texans.
Thank you.
Justice Jackson?
So Justice Barrett had exactly my same thought, and I just want to clarify. So this doesn't speak, in your view, to a business decision not to offer services in Texas because, for example, their requirements are too burdensome. Instead, this is you're offering business in Texas and everywhere else, but you are prohibiting them from discriminating against people on the basis of their geography, meaning they're in Texas.
Yes, Your Honor.
Thank you.
Thank you, counsel. Rebuttal, Mr. Clement?
Thank you, Mr. Chief Justice. Just a few points in rebuttal. First of all, as to the common carrier, the two classic elements of common carrier status are missing here. One is that you just transmitted or carried messages from point A to point B. That's not what's going on here. We use the word in our brief and from this court's cases, disseminate. Disseminate means to spread broadly. That means you're in the expressive enterprise business.
Really? So that's not what YouTube is doing? Really? That's not what Twitter is doing? Really? Disseminating broadly. Who can't see? What are you talking about?
There's zero tradition of treating entities in the expressive enterprise business as common carriers. And then the other factor is there really is like an essential facility. The telephone wires used to go, the copper wire, the last mile to every house in America. So if you were kicked off Ma Bell, you were really out of luck. This is the opposite situation in the internet where you have lots of other choices. This is just not.
Not if you want to communicate with a billion people. Not if you choose to communicate with a billion people and disseminate, to use your word, with a billion people rather than 20,000. So no, it's not at all the same thing.
Not a common carrier. Not that that really is talismanic under the First Amendment anyways. Justice Thomas made that point back in Denver carrier case, and he had it exactly right there. Now, second, public accommodation. I wouldn't be worried about any other accommodation law, public accommodation law. No other public accommodation law prohibits discrimination on the basis of viewpoint and applies exclusively to speakers. That is a First Amendment red flag that you're trying to limit speakers' ability to discriminate on the basis of viewpoint. That's just a frontal assault on editorial discretion. Every other public accommodation law that I'm aware of works differently. Third point, protecting kids. If you're at all concerned about protecting kids on the internet, that should be a vote in our favor in this case. Because if you can't do viewpoint discrimination, that disables us from doing many of the things that our companies try to do to protect use online. I mean,
no, it's not. That's got nothing to do with viewpoint discrimination.
You know, the idea that, okay, we're going to have to choose between having, if we have suicide prevention, we have to have suicide promotion to avoid viewpoint discrimination.
Which is a ridiculous framing. It is. It's a ridiculous framing.
That should be a non-starter. And protecting kids is important even as to the disclosure provision. There is a record on this case at page 161 of the joint appendix. A witness from Stop Child Predators testified and said these disclosure provisions give a roadmap to predators to figure out why their messages aren't getting to children. So they can figure out why they got bounced and they can try again and sort of work their way around. So the last point, and I think this is an important one to end on, this idea that somehow we're behind the eight ball because we brought a facial challenge. There is a proud tradition of facial challenges to vindicate First Amendment rights in this country. That's how many of these cases have been brought. There's an equally proud tradition of getting a preliminary injunction against a law that is chilling speech.
It's not chilling speech. It's trying to stop you from chilling speech.
And as the general pointed out, I mean, the party presentation rules have to be foundational here. If we had gone into the district court and said, this is unconstitutional on its face, and they said, no, it's not because of Gmail, we could have had a fair debate about that. We could have modified our complaint if necessary. That's a difficult issue. As I said, the only court that I've seen that deals with it directly said Gmail is not a common carrier. But in all events, we could have litigated all of that. But the plaintiff's burden is not to think of any theory the government can come up with appeal and then foreclose it in the district court. Thank you.
Thank you, counsel. All counsel. The case is submitted.
There you go. 3 hours and 20 minutes for me to go through an hour and 20 minutes. See, this is what I was concerned about. The other case is 2 hours and 20 minutes of argument. I really want to watch it. I just don't know how I'm going to do it. Because it's going to take me 5 hours. It's going to take me like 2 shows at least. Well, anyway, I gave you my thoughts. That was a lot of work on my part. Starting at 11 p.m. and going until 2:20 in the morning. So if they're all self-promotion, are they under 2/3 distributor and not publisher? The only self-promotion, are they under 2/3 distributor and not publisher? Well, they basically say that 230 applies to us because on its face, it basically refers to anyone who's providing this public service. So, whew, that was lengthy. That was pretty lengthy. I forgot to cover this. Fan said earlier, it gave us the Iraq War, WMD. This is talking about when he was addressing. I saw this when you brought it up earlier, and I forgot to address it. We were talking about what 1980s and 1990s conservatism, republicanism was. It gave us the Iraq War, WMD on conservative side. America First and populism has shifted our side of the aisle. Indeed, it has. I'll just only correct you that aisle is spelled with an A in that context. But yeah, everything you wrote there is correct. That aside from me being a bit of a grammar jerk. Sorry about that. I'm kind of sleepy. In case you can't tell. So with that, time for me to land my plane. Tomorrow, make sure that you hit like and subscribe. And tomorrow, I do plan on making an appearance on Locals. We're going to be doing a local stream tomorrow. So make sure you sign up for that. Goodlogic.locals.com. Goodlogic.locals.com. Time for me to land my plane because good golly, am I tired. And I will see you all tomorrow. But don't miss me too much. Don't get all sad that I'm leaving. I know some of you are sad. If that's how you're feeling, all I'm going to say is stay happy. Eat some bugs. And as always, my friends, God bless you for joining me. Hope you enjoyed. Good night. Godspeed.